All please rise. The Honorable Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please call the cases before us.
Good afternoon, Your Honors. This is a continuation of the oral arguments on the consolidated petitions in GR number 256282, Republic of the Philippines, represented by the Department of Agriculture, the Bureau of Fisheries and Aquatic Resources, and the National Telecommunications Commission petitioner versus Royal Fishing Corporation, Bonanza Fishing and Market Resources Incorporated, RBL Fishing Corporation, and the Honorable Regional Trial Court Judge Zaldi B. Docena, Branch 170, Malabon City, respondents. GR number 256559, Republic of the Philippines, represented by the Department of Agriculture et al., petitioner, versus Royal Fishing Corporation et al., respondents, and GR number 257049, Oceana Philippines International, Pablo R. Rosales, and Ronaldo P. Reyes, petitioners, versus Royal Fishing Corporation et al., respondents.
Councilors, please enter your appearances.
Good afternoon, Your Honors. Respectfully entering for petitioner, Republic of the Philippines, represented by the Department of Agriculture, the Bureau of Fisheries and Aquatic Resources, and the National Telecommunications Commission in GR numbers 256282 and 256559. I'm Solicitor General Menardo Guevara. With me in this afternoon's hearing are my Deputy Chief of Staff, State Solicitor Pearl Cherise Bautista, Assistant Solicitor General Elaine Rose Sanchez Coro, Senior State Solicitor Melanie Pimentel, and Senior State Solicitor Cheryl Angeline Roque Javier. Also present, Your Honor, are representatives of the agencies whom we represent, namely Department of Agriculture Undersecretary Drusilla Esther Bayate, BIFAR National Director Demosthenes Escoto, BIFAR Assistant Director Saldi Perez, NTC Legal Branch Director Attorney Andres Castelar Jr., Mr. Marlo De Moos, OIC of the VMS Center, and Mr. Francisco Torres Jr., Senior Science Research Specialist. We are ready for the resumption of hearing, Your Honor.
Good afternoon, Your Honors. Appearing for the petitioners in GR number 257049, petitioners Oceana, petitioners Reyes and Rosales. I am Michael Christopher De Castro, and with me are attorneys Mario Maderazo, attorney Pauline Tejido, and attorney Donatello Rustiniani. We have with us, Your Honor, the representatives of Oceana Philippines International. We are ready, Your Honor. Thank you.
Good afternoon, Your Honors. Respectfully appearing for the respondents in this case, Royal Fishing Corporation, Bonanza Fishing and Market Resources, Inc., and RBL Fishing Corporation. I am Attorney Arnold D. Naval, and with me this afternoon our attorney is Attorney Hilario Paul H. Ragunhan Jr., Attorney Neil Marvin F. Henzola, Attorney Amormia J. Francisco Naval, Attorney Herschel F. Magracia. With us also, Your Honor, are the representatives of the respondents, Mr. Ferdinand Y. Lim, Mr. Peter Paul D. Santos, Mr. Paulo Ivan L. Santos, Mr. Lance Lim, and Attorney John Brian Dico. We are ready to continue, Your Honors.
Today's afternoon session is for the continuation of the interpretation of the justices. May we call Justice Vicky Rosario to start the interpretation?
Thank you, Chief Justice. May I request the counsel for Royal Fishing to please approach the podium and accordingly respond to my questions.
Good afternoon.
Good afternoon.
Good afternoon,
Good afternoon.
Justice.
I have made a quick perusal of the written questions I have prepared. And I have noted that some of the questions I have listed, for to expedite the proceedings, were already covered by the interpellations made by my colleagues who spoke before me, who asked questions during the previous setting for the oral arguments, counsel. So I will try to avoid inquiring further on those matters unless I find it necessary to bring them up again for maybe clarificatory purposes or as a supplement to or follow up on these previous questions. Okay.
Yes, Your Honor.
Now, I recall you having stated in the previous hearing that the location, while at sea, and other data pertaining to your fishing activities are trade secrets.
Yes, Your Honor.
How did it become trade secret when it is something that, according to counsel for petitioner, can easily be accessed or detected by using equipment and devices designed for that purpose?
Thank you, Your Honor. Information as to the location of the fishing vessels, details as to their operation on that fishing spot are considered trade secrets by the fishing companies. They use plans and processes, tools and mechanisms to be able to determine that particular fishing spot. And all these mechanisms and tools they use are known only to them, Your Honor, to the owners, no? And only confided to specific personnel within their company. Okay. Now, this practice, Your Honor, this conduct that they exhibit, Your Honor, is recognized and accepted by our society. In fact, Your Honor, this has been part of the legislation of the Fisheries Code, Your Honor.
May I request the counsel to please limit your answer to the questions propounded by the examining justice. Okay.
Yes, Your Honor.
Now, if it is indeed a trade secret, attorney, how is the same protected under the law?
Under the law, Your Honor, Fisheries Code, Section 155, there is that provision which states that the department shall take measures as may be necessary to protect the trade, industrial, policy information of fisher folks, fisheries owners and operators, entrepreneurs, manufacturers, and researchers. When the disclosure of this information, Your Honor, will injure the competitiveness and viability of their fishing operation or domestic fisheries, Your Honor. So that's one protection provided by the law. If I may further, okay. Also, likewise, Your Honor, in FAO 266, there is a section there, Section 23, which provides that data coming from the vessel monitoring system shall be treated as sensitive technical information. That should not be that should not just be disclosed unless authorized, as per the FAO. And this section 23, Your Honor, is the same as the section provided in the Fisheries Code under Section 127. Again, it provides that this data coming from the VMM, vessel monitoring measure, as well as the vessel monitoring system, shall be treated as sensitive technical information and shall be treated in accordance with Section 155, or the one I mentioned earlier, Your Honor.
So that if this court were to sustain your position on this issue, trade secret, we could at least anchor our findings on these laws that you just cited or mentioned.
Yes, Your Honor.
You also claim previously that on the part of the government, represented by BIFAR, no? And other agencies, there will be a violation of the respondents, your clients, trade secrets, if the government implements or continues to implement FAO number 266, correct?
Yes, Your Honor.
Would you know, counsel, if there has already been an incident in the past, or could you possibly cite an instance when the government disclosed your so-called trade secrets to your business competitors?
Considering, Your Honor, that this has just been implemented. This is already implemented, in fact, Your Honor, but insofar as our clients is concerned, we are not privy to any disclosure made by the agencies holding this information, Your Honor.
Now, moving on. RA number 8550 was enacted to achieve food security as the consideration in the utilization of fishery resources in order to provide the food needs of the population. You are aware of that?
Yes, Your Honor.
This law was later amended by RA 10654 to strengthen the prevention, deterrence, and elimination of illegal, unreported, and unregulated fishing. obviously the law was passed in the exercise of the police power of the state. Do you agree?
Yes, Your Honor.
Which, as we know, is the inherent capacity of state governments to exercise control over the citizens and resources within their jurisdiction to better health services, general security, etc., etc. Now, I'm just wondering, Attorney, how do you think can the government effectively achieve its objective of ensuring food security and eliminate illegal, unregistered, and unregulated fishing, which regulatory actions are clearly well within its police power? If this court, the Supreme Court, will prevent the BIFAR from monitoring, tracking, and controlling the fishing activities of commercial fishing vessels.
Thank you, Your Honor. To answer that question, I believe there are two aspects addressing the concerns on fisheries management and eliminating IUUF. Okay. To answer the first part, Your Honor, whether the imposition of the installation of the vessel monitoring system is aligned with the policy on food security and fisheries management. It is our submission, Your Honor, that it does not. And our reason is that if the objective really is fisheries management, Your Honor, the imposition of the vessel monitoring system on commercial fishing vessels alone will not address the problem. Why? Because, Your Honor, the law itself provides that monitoring, control, and surveillance system will be established, and that this will include municipal, commercial, and distant water fishing. Now, this is what I'm saying, Your Honor. For fisheries management, statistics will show that if you really want to know or address the problem of fisheries management, the volume being caught by the total aggregate of municipal fishing vessels is even more than the aggregate volume being caught by commercial fishing vessels. PSA statistics will show that in 2020, 2021, 2022, the volume caught by municipal fishermen is over 1 million metric tons, while commercial fishing vessels go around the figure of 800,000. So why segregate the number of municipal fishing vessels from the installation of VMS if the real intention of the law is to provide a system that will aid in their fisheries management, Your Honor?
First, Attorney, what you're trying to point out is that the installation of this tracking, monitoring devices would have no bearing or nothing to do with its mandate of ensuring food security.
We believe so, Your Honor. And if I may continue, Your Honor, because the second part is regarding eliminating illegal, unreported, unregulated fishing.
It's an entirely different aspect.
Yes, Your
Right.
Honor. The imposition of VMS on commercial fishing, okay, it will give a data as to the location, Your Honor, okay. How will it deter or eliminate illegal, unreported, unregulated fishing? Number one, these illegal, unreported, and unregulated fishing are not registered fishing vessels, Your Honor. They will not have themselves installed with VMS. Second, Your Honor, these incidents require the actual presence of law enforcement agencies that are actually in place already, Your Honor, in our coastal states. There are task force, bantay dagats that patrol our waters. And they are the ones who can visually see and determine whether there are violations being committed. It will be a redundancy to provide the location when all this task force patrolling the boats, seeing the violators, already have GPS devices installed in their patrol boats already, and they know already. Yes, Your Honor.
Are you saying, Attorney Counsel, that if a fishing vessel is registered, okay, it is not anymore, it will not or not capable of engaging in illegal fishing activity?
Our position, Your Honor, is the fact that they are registered, they applied for a license and were approved. They've been compliant with the rules and regulations of the BIFAR and the Fisheries Code, Your Honor. But of course, they may be apprehended mistakenly because there are other factors that may come into play, Your Honor.
Okay, this is my next question. Should the court, let's say, affirm the assailed decision? I think that's RTC. Malabon o Nabotas? Ano ba?
Malabon, Your Honor.
And sustain your position on the main issues in this case. Ito naman kung alam mo lang, ano? What do you think would be the what do you think would be the recourse of the government?
I'm sorry, Your Honor, please.
Meaning, in your opinion, attorney, are there any other ways by which the government can efficiently perform its task or mandate to achieve food security without violating the constitutional rights of respondents, the privacy and lawful searches, etc.?
Yes, Your Honor. Presently, Your Honor, we are observing the manual reporting system. Now, when we say manual reporting, Your Honor, it's not really the simple writing down or typewritten reporting. It also involves electronic use of computer, Your Honor, but not real time. So in manual reporting, Your Honor, they use the data of the fish catch, the volume, the kind of catch, and collect them. And this should be collected for at least 1 or 2 years to be able to assess really, Your Honor, the actual condition of our fishing grounds. And from there, formulate policy on how to better manage and sustain our fisheries and aquatic resources.
So that is your suggestion or recommendation, ano? In the unlikely event that maybe the Solgen will consult with you on, what remedy or recourse they may have, if they use in this case.
Among others, Your Honor.
Now, this is my observation. Apparently, Counsel, you have smelled something fishy in the monitoring and tracking of your commercial fishing vessels, location and activities that led you to conclude that FOW number 266 violates your right against unlawful searches, among others. How so? Is there anything in the administrative regulation that authorizes or even requires the BIFAR or its agents to board, search, and inspect your fishing vessel for possible violation of BIFAR rules and regulations, or in general for violation of any law, say illegal fishing or smuggling?
Your Honor, they're authorized to board our vessels whenever we are conducting operation in the fishing ground or while we are navigating.
Sorry.
So, Your Honor, I said they are authorized. BIFAR is authorized, or the agencies are authorized to conduct usual inspection regarding our operation, Your Honor. Checking any compliance as to valid licenses or whether fishing companies are using the authorized gears, lighting system, and all those things, Your Honor.
I have additional questions, Attorney. One of the objections of respondent to POW number 266 is that it supposedly was issued in violation of its right to privacy. Correct?
Yes, Your Honor.
POW 266 provides for the guidelines or rules and regulations in the implementation of what? RA 8550.
550.
This is known as the Fisheries Code. This law would later be amended by another law, 10654, which essentially aims to prevent, deter, and eliminate illegal, unreported fishing. Under POW 266, fishing vessels are required to be equipped with vessel monitoring measures, BMM, a system that tracks, monitors, and manages fishing vessels and electronic reporting system, or that which is used to record, report, process, store, and send fisheries data. POW 266 even requires that both BMS should be turned on while the subject vessel at sea. According to your Royal,
Royal Fishing, RBL Fishing, Bonanza Fishing, and
Okay.
Market
the
Resources.
requirements under POW 266 would violate its rights of privacy, as making known the location of its vessels and the volume of its catch would give its competitors undue advantage of pinpointing the fishing grounds being covered by respondent.
Yes, Your Honor.
Respondent alleges that the choice of their fishing grounds is dictated by several factors that they meticulously study to come up with the most feasible areas on which to fish. Revealing their locations and other details to the fishing authorities supposedly amounts to forcing it to reveal trade secrets that otherwise are protected by law.
Yes,
Tama.
Your Honor. Tama po.
What respondent envisions is once the location of his vessel is made known through the monitoring system, its competitors would most likely swarm the fishing ground where its ship is located, resulting in reduced volume of catch, all because its competitors was able to gain access to its trade secret. Di ba? Yan ang sinasabi
Yes,
niya.
Your Honor. Opo.
Now, this is my question. You allege that the monitoring system put in place by FAO 266 violates your right to privacy. What exactly does FAO 266 in its monitoring aspect cover?
Can you please repeat, Your Honor? Sorry.
Because it is your claim that PAO 266 violates your right to privacy. Now, my question is with respect to the coverage of this PAO 266. If you know.
Yes, Your Honor. Your Honor, there are sections in FAO 266 that violate the right to privacy of the respondents in relation with their trade secrets, Your Honor. If I may focus on that discussion, Your Honor, because the other aspect regarding right to privacy, as we have submitted in our written manifestation, is
I will just withdraw that question if it would entail a long response on your part. I'll go to my next question na lang. Supposing PAO 266 will require only the disclosure of your ship at any given time while engaged in actual fishing operation, will you still consider this a violation of your right to privacy? Maiksi lang, Attorney Sagot.
Yes, Your Honor. Your Honor, the real-time continuous monitoring collection of information as to the location and volume of fish being caught is a violation of the trade secret of the fishing vessels, of the fishing companies in relation with the right to privacy, Your Honor.
Your answer is yes, in other words.
Yes, Your
Okay.
Honor.
If without the accompanying requirement of revealing the fish variety of your catch and its volume, will you still deem the rule to be an infringement into your right to privacy?
If the manner of collecting data is not real time, Your Honor, it will not anymore be as injurious to the competitiveness and viability of the fishing operations of the respondents, Your Honor.
So what's your answer? Affirmative.
Yes, Your Honor.
Okay. Now, if merchant ships, for safety and security reasons, should also be required to install locator devices, will there be a violation of the right to privacy, in your opinion? My question is, what is so wrong with the state in the exercise of its police power, as I mentioned earlier, in promulgating laws for general welfare, as in the instant case of PAO 266, whose objective is to curb illegal fishing, to inquire and be given instant information as to the location of ships and vessels?
Your Honor, because that regulation still should be subject to the fundamental constitutional rights of the respondents, Your Honor, against the violation of their right to privacy, Your Honor, in relation with their trade secrets.
Now, the idea actually is to drive home the point that there is nothing wrong with monitoring the movements of vessels. And there could not, in such case, be any violation of right to privacy. At least that is the view taken by, of course, the opposing counsel. Now, you fear that by revealing your fishing spots, you would be giving your competitors undue advantage, as they will just have to cross the fishing ground you are probing if they should come into that information, correct?
Yes, Your Honor.
However, if only the location of your ship during its fishing operation is disclosed, without necessarily revealing whether the spot your ship is located is a prime fishing ground, will that still invite your competitors to storm your chosen fishing area?
It will be considered by them, Your Honor, already.
Okay. Would it not be foolish for your competitors to proceed to your fishing ground if they are not sure that abundant catch awaits them there?
Your Honor, we cannot speak, but the idea of the nature of the business of the respondents is capture fisheries, Your Honor. So the fish there is being hunted down to be caught. And so once, for example, the fishing company or the respondents was able to determine its location, other fishing companies would naturally take advantage of that and also to address the recovery of their investments and take advantage of that competitiveness of being able to catch the same bountiful fish, Your Honor.
The point I'm trying to drive at, per se, is that disclosure of your ship's location, which, by the way, is given some guarantee of confidentiality by PAO 266, is not at all completely wrong. What you consider repugnant is the possibility of revealing what you consider to be your trade secrets, correct?
Yes, Your Honor.
This apparently is possible only if the location of the ship simultaneous with other fishing details, most especially the catch volume, is made known to your competitors. Do I get it right, Attorney?
Yes, Your Honor.
Thus, in determining whether or not there is a violation of your privacy, so as to give unwarranted benefit to your competitors, it is not enough that the ship's location is disclosed, but the result of your foray into particular fishing ground, particularly the volume of the catch and the variety of the fish. Tama, no?
Mhm.
And according to you, your choice of fishing grounds is a trade secret that only your team is entitled to know.
Yes, Your Honor, but if I may please.
Go ahead.
Okay. Your Honor, we share the position of this honorable court when it declared in the case of Dicini versus Secretary of Justice that when it declared a section of a law as void and unconstitutional, that law giving law enforcement agencies the power to collect and record data electronically and technically in real time. It says mere collection and gathering of traffic data in real time. And further, this honorable court later on said that even though or while that law says that it should not reveal the identity of the sender or the receiver and the content, such restraint is but an illusion because nothing will prevent the law enforcement agency holding possession of this data. Nothing will prevent them from looking into the identity of the senders and the receivers as well as the content. And this will unnecessarily expose the citizenry to leaked information or worse, extortion. We
Okay.
share the same position, Your Honor.
Ulit-ulit mentioning this trade secret. Will you kindly define what trade secret is, even in your own words, Attorney?
Well, trade secrets, Your Honor, for us, it is a plan. It is a plan, just like in the case of Air Philippines, but it is also our own submission. It is a plan or process that the fishing companies use along with compilation of data, tools, equipments, gadgets that only these owners know, and they share with their key personnel, particularly the maestro pescador. And they use this, Your Honor, continuously in their business. So they will have a competitive advantage, of Your Honor, to other fishing boat operators.
Anyway, the legal definition of trade secret is that, as you're correct, it is a plan or process, tool or mechanism or compound known only to its owner and those of his employees to whom it is necessary to confide it. The definition also extends to a secret formula or process not patented, but known only to certain individuals using it in compounding some article of trade having a commercial value. Okay? Tama ba yun? Mali. Mali yun. Tama, no?
Yes, Your Honor.
Given that definition, will you kindly explain how and why you consider your choice of fishing ground a trade secret? What factors do you take into consideration before leaving for the fishing ground of your choice? Do you have any special equipment to guide you in arriving at your decision on which area to fish? And are you aware whether such equipment is also available in the ships of your competitors?
Your Honor, these trade secrets of the fishing companies, they were developed through years of experience, Your Honor. Now, because of the years of experience, they have already historical data collected. They have already compiled this information where they caught bountiful fish, where they caught fish that are not yet matured, where they can come back to it after a few months or a certain period of time. And all this they compile along with, Your Honors, the proper tools, equipments like the, the right or appropriate gears, nets, the right size of the eyes of the nets, the right power blocks, winches, the right equipment finding the fish like the sonar equipment, the right model that is suitable to their size of operation, Your Honor. All these things come into play until at the start of the fishing season, they determine now through their plan and process where to initiate and go to what particular spot in the fishing ground they would start their operation. Your Honor.
Kayo lang ang may ganong equipment.
No, Your Honor.
As far as you know.
Fishing companies have different approaches in their operation, Your Honor.
I read somewhere in one of your pleadings that you exclusively or nearly exclusively fish for galunggong and are not want to try landing other varieties of fish, including migratory ones, correct?
Yes, Your Honor.
If I'm not mistaken, you asserted that in case of migratory fish, and I have known it from several other fishing documentaries, there is basically no system that allows an accurate prediction of the movement of this fish, much unlike in galunggong. Okay? Do I get it right that in galunggong fishing, you can at least predict their movement because fish of this variety do not move around far and tend to stay within a limited confine of the sea or the ocean? Is that correct?
It's correct in a sense, Your Honor, that small pelagics like galunggong, Your Honor, they feed primarily on planktons or small animals that hovers along the surface of the ocean. Now, with that, they linger only in a particular place, but they're still moving around. In the vastness of that fishing ground, they move. Now, it would take knowledge of other factors, Your Honor, where the tendency of those schools of fish would go in that particular fishing ground, considering the temperature of the water, the current of the water, where these planktons will shift. Your Honor.
Dami mong alam. Siguro ko, lawyer ka lang o sumasama ka sa... Anyway, this some of the things that you did are too technical for me to understand, honestly.
Thank you, Your Honor.
Now, going back to galunggong. With regard to galunggong fishing, if their movement is more or less predictable, and that is my observation, personal observation, will it not stand to reason that what you can predict could just as easily be anticipated by your competitors?
By experience, Your Honor, by fishing companies, it is not, Your Honor. We take exception to the observation of the Honorable Justice that
Galunggong.
movement of small pelagics are easily predictable, Your Honor.
Thus, if I may continue,
Yes,
Attorney, the natural habitat of said galunggong, regardless of any extraordinary effort you put into locating it, is known not only to you, your client, but to your competitors. They could predict just as easily the location of schools of galunggong as you do. And in this scenario, where almost all vessels could just as easily locate galunggong because of their limited movement, should there still be some trade secret worth keeping, or would this not be a useless exercise?
We submit that it is not, Your Honor, because, okay, predictable as it may be perceived by the Honorable Court, the ocean is vast, Your
Ako
Honor.
lang, hindi sila kasama. So,
Yes, Your Honor.
go ahead.
The ocean is still vast, Your Honor, that due to the limitation as to the resources like fuel, ice, and expenses incurred by the fishing companies in their operation, it is necessary for them to optimize the movement of their companies in knowing as much as possible, as effective as possible, efficient as possible, to determine that particular spot in the fishing ground. That's why, Your Honor, for us, it is still their trade secret as to how fast they can get to that fishing spot, how efficient they can get that desired volume and kind of fish that they want.
Pag di ba tayo tumigil dito, baka hindi na trade secret yan. Ha? Another hypothetical question, Attorney, that's okay with you. Supposing, after due regard of the trade secrets you are referring to, you should head out to your fishing ground destination. Okay? Patapos, ano ba, a competing vessel, no? Supposing further that a competing vessel would tail you, susundan ka, to the very spot that you have chosen, or at least within the vicinity of said fishing ground. That's not illegal, di ba?
No, Your
Okay.
Honor. No, Your Honor.
Will you have the right to send them away
No, Your Honor.
on the ground that they would be fishing on some choice location that you have singled out as a result of your trade secrets?
Your Honor, if that other competitor obtained the information independently, whether from his resourcefulness or other sources, then we cannot prevent him from
Susundan lang,
susundan lang
Yeah.
yan po. Opo.
Hindi mo bawal yun, di ba?
Yes po, yes po.
Now, if you should have no right to drive them away, why then do you suppose you could invoke trade secrets or your right thereto in impugning FAO 266?
Because, Your Honor, them being able to find us, follow us, does not mean that they know exactly our trade secret or where we will go. Other fishing companies may employ, say, for example, they notice that they're being followed. They can also have a counter move to, for them to either lose or perhaps make a decoy. These options or prerogatives are available to the fishing boat operators also to protect their business, of course, Your Honor.
I will explain. The point is that you will be fishing in the high seas or the exclusive economic zone of the Philippines or in municipal waters. You will go about your business in a very public manner. You will proceed to your destination in open view of the public, or at least your fellow fishermen. You will do every aspect of your fishing in the open, from the casting of the net to the hauling of the fish to your vessels. Under this circumstance, how could you keep or consider your fishing activities to be a secret, one that should be entitled to full protection of the Constitution, like any other business undertaking?
Your Honor, in relation with our trade secret, with the trade secret of the fishing companies, they still have informational expectation to informational privacy. With respect to them being looked at, observed at while they are doing, of course they do not have, because that will pertain already to the locational privacy, which they do not enjoy at that very moment. But what they have is the privacy as to the information that they have, which they have the right to whether to disclose it, to share it, and also they have a certain privacy within the premises of their vessels also, Your Honor. But with your example, Your Honor, that is not covered by their right to privacy.
In relation to the right to privacy, last two questions na lang po. How does the engagement of a private service provider from the United Kingdom for the installation of the BMS and ERS violate the fishing vessel's right to privacy? Does this alleged violation have any data privacy implication under existing Philippine data privacy laws?
Your Honor, the engagement of private individuals, for us, it's a violation already of the requirement of protection of this sensitive technical information. Why, Your Honor? These private individuals, again, they have no contract with the government. They are service providers owned by foreigners, Your Honor. This information supposedly is treated by law as sensitive and technical and should not be disclosed if it would injure the competitiveness of the fishermen or the fishing boat operators. Now, what this FAO or the Bureau or the Department of Agriculture and Bureau of Fisheries did was that they even involved other individuals who did not even bother to undertake or execute any non-disclosure agreement, Your Honor. So for us, that is a violation of.
This is
Their
my last
right to
question
privacy.
for Royal Fishing. Royal Fishing asserts that PAO 266 violated the Equal Protection Clause of the Constitution,
Yes, Your Honor.
as it governed only commercial fishing vessels,
Yes.
not municipal fishing vessels.
Yes, Your Honor.
In this regard, can you elaborate on how commercial and municipal fishing vessels are similarly situated relative to the targeting of straddling and highly migratory fish stocks? Don't their differences in terms of access to technology, equipment, and manpower constitute substantial distinction to justify differential treatment?
Your Honor, our position is that first, the law provides that the law provides that municipal fishing vessels should also be covered by the installation of or compliance with the vessel monitoring measure. Now, both municipal and commercial fishing are within the same classification of capture fisheries, Your Honor.
Okay.
They catch fish. Now, if the objective of the FAO is fisheries management, determining the fish stock within a fishing ground, not including the municipal fishing vessels, which is vast in number and has even a more total aggregate volume of catch, would not be consistent with the purpose of the law, Your Honor. For example, Your Honor, they are monitoring only fishing vessels that are catching commercial fishing. They are catching 15 kilometers and beyond. If we are really to monitor our marine resources, why are we just monitoring fish that are beyond 15 kilometers? Why not monitor also the ones within the 15 kilometers, Your Honor? And in fact, they are being, more fish are caught by the municipal fishing. So it really is not germane to the purpose of the law, Your Honor.
Okay,
So it's not-
sufficient.
Okay.
Your answer.
Thank you.
Thank you very much, Counsel.
Thank you, Justice.
Chief, OSG, I think it's now the turn of the OSG to take the podium.
Thank you.
2 questions lang po, Secretary Guevara. If
Good
I
afternoon.
good afternoon. If I understand it correctly, before the promulgation of PAO 266, the monitoring of fishing activities consists mainly on some written declaration of the fishing activities of vessels made and submitted at the conclusion of their journey.
That is correct, Your Honor. Prior to the adoption of the VMS, catch reporting has been done manually, and that was done only at the end of the fishing trip. when the fishing vessel returns to port and submits the data about its catch.
So, Mr. Soldier, if this court should finally invalidate PAO 266 before another fishing authorities would be forced to revert to implementing the previous rule or system.
Your Honor, first of all, I do not think that this honorable court will affirm the ruling of unconstitutionality by the regional trial court. But should that very unlikely event happen, of course, it's a huge step backwards. We are trying to digitize, to modernize the way we do fisheries conservation and management. And if this court rules that the VMS or the issuance of PAO 266, which imposes the VMS, is unconstitutional, then we revert to the old ages of submitting data about catch manually. Of course, there are other possible measures that we may adopt, but from our own assessment, Your Honor, the matter of the VMS is the most narrowly drawn. It's the least restrictive. It's the most cost efficient. So that, in our opinion, Your Honor, is a policy that our legislature has adopted pursuant to the state's constitutional obligations to protect the marine environment and the general environment, plus the fact that all of these resources are owned by the state to begin with. Thank you.
Okay. But the old method or system will always remain to be a fallback.
Yes, Your Honor, it would seem to be that way if this digitized system of reporting will be struck down, then we just have to go back to manual reporting.
Now, in your opinion, does this previous system, or to be accurate, the current system of monitoring in light of the decision of the court, Judge Oceana, provide for an effective means to realize the objective of RA 10654, that is, to prevent, deter, and eliminate IUUF, or the illegal, unreported, and unregulated fishing?
Your Honor, there are other ways of dealing with IUUF, but the adoption of the VMS is the most efficient, most effective of all these means, because what other options do we have? We have to rely on sea patrols. We have to rely on information thrown by other persons, like maybe some fishing vessels with different flags. So, Your Honor, we really believe that apart from fisheries management and conservation, this matter of dealing with IUUF is best addressed by the adoption of the VMS. It is the quickest, real time. If the satellite gives information that an illegal fishing act is being committed, then that information is relayed immediately to the proper authorities, to law enforcement agents, who might then take the appropriate action to quickly apprehend the illegal act being committed. Because otherwise, Your Honor, it will be very difficult to police, to patrol all Philippine waters. I understand that we're dealing with something like 37,000 kilometers of coastline. So plus the EEZ, the high seas, so it's almost physically impossible, Your Honor, that the traditional way of trying to deal with illegal fishing, unregulated fishing, and unreported fishing could be done.
Anyway, are there any safeguards in the current monitoring system that would ensure or compel fishing vessels to make complete and honest declaration as to their fishing activities?
Your Honor, since manual reporting is done by human individuals and with the benefit of much time, because they will submit these reports only when they return to port after weeks or months at sea, then the possibility of providing inaccurate or false information is very high. Unlike when we do it real time, Your Honor. And when these vessels return to port, their catch can be validated by the earlier reports transmitted electronically.
Last question po. There was mention of this issue with European, ano ba ito? European Union.
Yes, the Maritime
Okay.
Affairs and Fisheries Commission of the
Okay.
European Commission.
What if a new monitoring system is put in place? One that should require fishing vessels to install tracker devices as to their exact location, and which should remain active at all times that they are engaged in the fishing activities, but without sending additional data in real time. Will this help fulfill the objectives of RA 10654 and help deter IUUF? Will this meet the requirements of the European Union? That's my last question.
Your Honor, the requirements of the European Union do not cover only location information on let's say the location of the vessel which caught the fisheries products being exported to the European Union, but it must be assured by the certification of the appropriate Philippine government agency, more particularly the BFAR, that the catch being exported to the European Union did not originate from IUUF or illegal, unreported or unregulated fishing. So in my opinion, Your Honor, if we just state information as to the location of the vessel, then that may not be enough. As a matter of fact, there is a very detailed form that needs to be filled up by the vessel, the vessel owner, who will be exporting certain products to the European Union. And that includes numerous information apart from the certification of the government agency concerned, showing, as a matter of fact, that the fish or the fishery products being exported to the European Union were not caught illegally or did not violate IUUF regulations.
So na lang pala, I have to ask you this question, Mr. Solicitor General. The Republic, through your office, went directly to this court, seeking relief under the claim that the present controversy is environmental in nature. How so?
Right from the beginning, Your Honor, this case has been classified as an environmental case. This was filed by the respondents now with the regional trial court in Malabon as an environmental case, and it was referred to the branch of the court that handles environmental cases. And that matter is not disputed, Your Honor. The subject matter of the complaint is the enforcement of certain provisions of, well, in fact, it's about the validity or constitutionality of FAO 266, the administrative order which enforces the vessel monitoring system. And by the very subject matter of the case, Your Honor, it is very clear that it pertains to the enforcement of environmental laws.
So my question, Attorney Guevara, is this. Is declaratory relief, yun yung pinalyata,
Yes.
the proper remedy to assail the constitutionality of PAO 266?
Your Honor, we argued in our pleadings that declaratory relief was an improper remedy availed of by the petitioners there at that time, which are now the respondents, for several reasons. First of all, Your Honor, at the time that the petition for declaratory relief was filed, PAO 266 was already being implemented. As a matter of fact, vessels belonging to the respondents herein now had already been installed with VMS devices. So at that point, there was already a breach, so to speak. So in my opinion, a petition for declaratory relief was improper.
Sir, thank you, Chief Justice. Yeah.
Thank you, Justice Rosario.
Thank you, sir.
Justice Alameda will conduct interpretation. Thank you, Chief.
Can we ask the representative from the OSG to answer questions? Anybody from the OSG?
I will. Good afternoon, Your Honor. I will answer the questions
Thank
for
you.
the OSG.
Thank you, Mr. Soldier. PAO 260 and 266 pertain to the implementation of the VMS and the ERS. Now, prior to this both 260 and 266, as you mentioned a while ago, the government requires manual reporting to address the issue of IUU fishing. Am I right?
Yes, Your Honor.
Yeah. Sir Soljan, can you please explain before this court the principal difference between PAO number 260 and 266 pertaining to fishing vessels covered and to fish stocks targeted?
Your Honor, PAO 260 pertains to commercial vessels which are operating in the high seas and targeting straddling or highly migratory fish stocks, such as tuna and tuna-like species. PAO 266, which is the subject of this case, Your Honor, is an amalgamation of all the preceding fisheries administrative orders, in the sense that it covers Philippine flag commercial vessels plying Philippine waters, including the EEZ, or the Exclusive Economic Zone, as well as the high seas and areas in the high seas which are covered by the EEZs of other countries, but in which we have been granted access by agreement. As to the fish stocks covered, Your Honor, since fishing vessels which are operating in Philippine waters, such as the EEZ, are also covered by PAO 266, it follows that even those fish stocks which are not highly migratory, for example, the pelagic and the demersal fishes,
Including the galunggong.
yes, Your Honor, would be covered by PAO 266, as well as the highly migratory species found in the high seas. So 266 is the more comprehensive fisheries administrative order, Your Honor, because it covers not only Philippine waters, but also the high seas.
Thank you, Sir Soljan. Now, can you give us any international agreement, treaties, or treaty obligation that requires the installation of PMS for vessels to include all other fishes, not only highly migratory and the straddling fishes?
Your Honor, there are quite a number with general provisions for the adoption of VMM, vessel monitoring measures, which include this VMS device. So for those that are targeting highly migratory fish stocks, we have mentioned this during the initial oral arguments. For example, the Convention on the Conservation of Highly Migratory and Straddling Fish Stocks in the Western and Central Pacific Ocean, the one also covering the Indian Ocean tuna, and also the southern, no, not the south, but there's another one, Atlantic tuna. But if your question, Your Honor, is for
Other fishes.
agreements covering other fish stock, first of all, there's the UNCLOS. Another one, which is a very general
Yes.
treaty. The other one is the 1995 UN Fish Stocks Agreement, which is equally as broad and general as the UNCLOS. And we have the FAO Code of Conduct for Responsible Fisheries. And there are a number, Your Honor, of international treaties which deal in general with conservation measures, which include the adoption of VMM or VMS, to be more particular.
So in recent years, there is no particular international agreement or treaties which focuses on all kinds of fishes to be covered by the VMS requirement. It's merely the general law on the fishing, the UN UNCLOS.
Yes, Your Honor, the general treaties. But for more specific types of fish stocks, then we have the regional conventions to speak of.
So what then prompted the Philippine government to issue FAO 266 to modify FAO 260?
Your Honor, I think this is the long-standing problem of dealing with fisheries conservation in general and the unabated problem of IUUF. Plus the fact that there has been this yellow card issued by the European Union, which warned us and classified us as a country which is bordering on the category of a non-cooperating country.
Yeah.
So I guess that particular incident prompted the government, more particularly the Bureau of Fisheries and Aquatic Resources, to be more aggressive, more assertive in the adoption of vessel monitoring measures, including the VMS. So that is what led in 2018 to the issuance of FAO 260, and later on, 2 years later in 2020, with the issuance of FAO number 266, the subject matter of this case.
Are we saying that FAO 260 is insufficient to the requirements of the law with respect to UII fishing, Mr. Sergeant?
Because FAO 260, Your Honor, dealt only with commercial vessels operating in the high seas and targeting only highly migratory species. So for a broader cover or more inclusive coverage of the vessel monitoring system, FAO 266 came about in 2020, in October of 2020, so that not only the migratory fish stock in the high seas would be covered, but also even those in Philippine waters, including our EEZ. So it's a more comprehensive or a broader approach to our fisheries conservation measures and our efforts to deal with IUUF.
When did the EC or the European Council issue to us a green status insofar as the cooperation of the Philippines with respect to these policies of the European Council?
Your Honor, we got the yellow card in 2014. We were bordering already on being a non-cooperating state. But because of that yellow warning, Congress came up in 2015, the year following, with Republic Act number 10654, which is the IUUF law, and which amended the Fisheries Code of 1998.
And then pursuant to this, the government or the BIFAR for that matter issued FAO 260.
Pursuant to that, yes, Your Honor, it was a follow-up to what the Congress had already done. So Congress passed the law, then the administrative agencies like the BIFAR would have to issue the appropriate implementing regulations. So the FAO 260, there were others, Your Honor. And finally, FAO 266 came about.
And then with the issuance of FAO 260, we had the green status.
With the yellow card was lifted way back in 2015 when we had the national action to address IUUF, and Congress passed the IUUF law. At that time, Your Honor, in 2015, the yellow card warning was lifted. So if we may consider that, being back to green, then that is correct. But since then, we have had many communications with the European Union, and we had been advised that our compliance with our commitments, international commitments, had been rather slow and not complete. So that's why the issuance of this consecutive FAO issuances by the BIFAR.
So what is the status of the Philippines right now insofar as the cooperation to IUU fishing is concerned?
With respect to the
The
European,
present status.
with respect to the European
Yes.
Union, if we do not comply 100% with the requirement to equip our commercial fleet with a VMS, by the end of the year, we understand that the European Union will take formal actions, whatever that means, Your Honor. It could mean that they may restore the yellow card, or worse, a red card, which means that our exports of fisheries products to the European Union may be banned.
So can you furnish us or discord with the communications from the European Union with respect to this warning on the part of?
We will do so, Your Honor. In fact, we have copies, so we'll probably attach them to the memorandum if the court will require us to submit a memorandum.
Also, Mr. Soljan, in section 23 of FAO 266, it recognized that the data gathered and acquired from the VMS are sensitive technical information. Can you explain how the BIFAR will handle and secure this sensitive information?
Your Honor, the only people who can access the data gathered through the VMS are the authorized persons of the BIFAR itself. And also, this information will be made available to the owners of the vessels who provided the data. No other persons will have access to those data.
How about the SRT Marine, the private foreign provider of VMS?
Your Honor, the SRT Marine was the winning bidder in the matter of procuring the VMS devices. But that's the only participation that they had. They devised the system, They encrypted the whole system, but the synchronized key for the transformation of the encrypted data would be with the BFAR only, but that would not be accessible to the SRT, which formulated the program.
Is there a need for the foreign provider, I mean SRT Marine, to sign any confidentiality or non-disclosure agreement with BFAR with respect to this arrangement?
According to the IUUF law, Your Honor, even the fisheries code, should a private service provider be engaged by the government, a non-disclosure agreement would have to be executed to ensure the confidentiality of data gathered through that system. And I understand that BFAR actually had that kind of agreement with SRT Marine.
You mentioned a while ago that prior to the issuance and implementation of 260 and 266, there was this manual reporting method
Yes, Your Honor.
undertaken by fishing vessels. Now, do you think that these measures are not sufficient and effective to prevent this IUU fishing in the Philippines?
They may to a certain extent be effective if we assume that all fishing operators were honest people, Your Honor.
Which is impossible to happen. Now, just asking Mr. Soljan, what is the status of the fish production in the country now? Is it on the decline or
Your Honor, status
of the fishing production, the fish production in the country, meaning the number of fishes in our fishing grounds?
I do not have the data right now, Your Honor, but my understanding is there has been quite a decline in total harvest of all species.
Do you think that the main reason for this decline is the IUU fishing?
Partly due to IUUF fishing, also partly due, Your Honor, perhaps to our inability to have a very comprehensive and very effective conservation and management program.
Can I ask the council for the respondents? Council,
Good
you
afternoon,
mentioned,
Your Honor.
good afternoon. You mentioned about a certain graft charges previously the last hearing filed against the government officials of the BIFAR, and then I think it's the private foreign provider of the VMS. Can you elaborate on this and tell this court about it?
Okay. Your Honor, we're actually not privy to that case. First, we learned about it in the news, but it so happened after the hearing that day, we were talking with the respondents, and they were actually furnished a copy for some reason of the complaint. Essentially, this is an ombudsman case filed regarding the acquisition of the VMS, regarding the VMS award to SRT. Initially the government was willing to provide. Initially there was an offer from the French government, for a loan around 1.6 billion. Now, as early as 2016, Your Honor, invitation to bid for this vessel monitoring system has been issued. Now, 2018, it was awarded to SRT, a British owned company, a British company. The French company I mentioned, Your Honor, because the French, it was a loan coming from the French to be given to the government to buy the vessel monitoring system. It so happened that it was SRT, based on my readings of the complaint. It was SRT who participated. So there was a failed bidding. And then there was a bidding again. And eventually SRT got the contract. But this time, the French loan was no longer offered because their condition was that it should be a French company. Okay. Now, after that, the award was given to SRT for 2,999,000,000 something around that figure, Your Honor.
The funds still coming from the French government?
No more, Your Honor. It will now be coming from the coffers of the Philippine government. And they are providing this entire system and equipments for free to the commercial fishing.
And what was the reason for the filing of this graft complaint?
Your Honor, because we are not privy to that, maybe in our memorandum we can
Yes, please.
provide.
Can you explain us the Supreme Court decision of Nuts versus United States as distinguished from US versus Jones with respect to in Nuts versus US, there was a tracking device which was placed in the container bought by the suspect. According to the US Supreme Court, this is constitutional. However, the Supreme Court in US versus Jones have a different position. Can you expound on this a little?
Your Honor, with your kind permission, the topic regarding US versus Jones, particularly in relation to unlawful searches, we have assigned the interpellation to be answered by my co-counsel, Attorney Paul Ragunhan, with your kind permission, Your Honor.
Yes, please.
Good afternoon, Your Honor. Your Honor, in the case of US versus Jones, the US Supreme Court, this is a 2012 case, Your Honor. The US Supreme Court held that the installation by the government of a GPS device or the global positioning system device on a vehicle, Your Honor, constitutes a search, and that a vehicle is considered as an effect, and thus that search was considered impermissible and it falls under the protection of the Fourth Amendment, Your Honor. The other one is the Katz, Your Honor. Katz
Nuts
case.
versus US.
Yes, Your Honor.
Nuts versus US.
Your Honor, in the case of Katz versus US, that was a case decided way before US versus Jones. In that case, Your Honor, it involves the installation of an eavesdropping device outside a public phone booth. Although a public phone booth, Your Honor, is not considered a constitutionally protected area, like one's body, one's residence, houses, the US Supreme Court held that there was an expectation of privacy of the one making the communication inside that booth. But in US versus Jones, Your Honor, it explained that the basic concept of search, which is physical intrusion or trespass into a private property, remains. But in CATS, there was just an expansion of that basic principle that even though you are not in a constitutionally protected area, you can still invoke privacy as in relation to unreasonable search and seizure if you have an expectation of privacy to be in that area, Your Honor.
So you are saying now that this installation of VMS is violating of the right to security.
Right against unreasonable search and seizure, Your Honor. Definitely, Your Honor.
Just one last question to the Solicitor General.
Good afternoon again.
Yeah, good afternoon. So right now, the Philippines have complied with the international convention and agreements regarding UUUI, so far as the Philippines is concerned, because we were given a green status.
With respect to the European Union,
Yes, with
yes,
respect
Your
to
Honor.
European Union. Now, this insistence of the European Union for us to install VMS on all catcher fishing vessels, is this a demand beyond the international agreements? As you stated a while ago, there was no specific international agreement with respect to this installation of BMS for all kinds of fishing, fishing of all kinds of fishes.
It appears from the various communications from the European Union Directorate General for Maritime Affairs that no qualification has been given as to the commercial fleet that needs to be equipped with a VMS. So while it is true that with respect to the European Union, probably only tuna and other highly migratory species would be involved, it is also possible, Your Honor, that, I'm sure that it is also possible that certain stocks of tuna may actually be in Philippine waters and not only in high seas. And therefore, considering that possibility that some species which are highly migratory could also be found in Philippine waters, not only in the high seas. That's probably the reason why the European Union would like that all our commercial fishing vessels be equipped with VMS. As a matter of fact, we're approaching that target, Your Honor, as of this time. About 2/3 of the entire commercial fleet have been equipped with the VMS, and only a few remaining, including the respondents, private respondents in this case, have not completely complied. But all the rest, 2/3, have complied.
So apparently this is an imposition of the European Union to us.
It's not really an imposition, Your Honor, because the European Union is simply asking the Philippines to comply with its international obligations. We are members of the Convention for the Conservation of Highly Migratory Fish Stocks in the Western and Central Pacific. That's where our tuna are mostly caught, and from there exported eventually to the European Union. So it's not as in a foreign country is imposing something on us. The European Union is simply requesting us to comply with our international obligations, because the resolutions adopted by the commission, those regional commissions, are binding on the Philippine government. Those conventions, Your Honor, have been ratified by the Philippine Senate and therefore have become part of the law of the land.
Do you think that this is more of a political issue than a legal issue, Mr. Soljen?
Well, we have always have had many issues with the European Union. For example, human rights has always been an issue with the European Union. But I'd like to say, Your Honor, that in this particular case, I think it is for the good of both parties, not only the European Union, but also the Philippines, that we comply with our international obligations. That's not so much for them as for us, because we'll be doing so as part of our efforts to manage properly our fisheries resources, apart from being able to comply with our international obligations.
Thank you, sir.
Thank you, Justice Salameda. We now call for interpellations. Justice Amy.
Thank you, Senior Associate Justice Marvic Leonen. May I call on the respondent's lawyer, please?
Good afternoon, Madam Justice.
Yes, Mr.
Yeah.
Counsel. You said that the government's choice of installing VMS is not effective, and it was not well studied. It was inadequate. There was no enough research that would support that choice. My question is not the choice of the means by which a law is implemented a question of wisdom?
Your Honor, the question of wisdom in regards to the choice of the system to be used, if it's adequate or not, I believe we submit that it should be determined after observing the requirement of a consultation, that regulation to be formulated should be based on scientific studies with the participation of the stakeholders who would be able to also participate and provide any wisdom coming from them as to whether it is adequate or effective, Your Honor.
So you want to share with the exercise of wisdom by the government?
Yes, Your Honor.
Is there any law that requires you to share your wisdom with the government when it comes to the choice of means by which the government implements its mandate under the law and the Constitution?
Your Honor, we have Rule 65.2 of the Fisheries Code, which provides that for the formulation of rules and regulations, it has to be based on scientific studies.
All right, the science include your involvement in the decision-making of the government?
Yes, Your Honor, it's a constitutionally provided right.
Where in the Constitution is that found?
In
That when
article,
it comes to scientific processes to be applied by the government, the stakeholders should weigh in.
we submit, Your Honor, that it is provided under Section 16 of Article 13 of the Constitution.
Can you read that, please?
Yes, Your Honor. It mentions that the right of the people and their organizations to effective and reasonable participation at all levels of social, political, and economic decision-making shall not be abridged, and that the state shall, by law, facilitate the establishment of adequate consultation
All
mechanisms.
right.
Yes,
Is that
Madam Chair.
self-executing?
No, Your Honor. That's why there is an IRR provided in the Fisheries Code for
Does the
that.
IIR provide that right?
Yes, Your Honor.
Can you read the IRR?
It provides 65.2, Your Honor. Okay, these are my notes. Can I get a hold of the actual publication, Your Honor?
Yes, sure.
Just a moment. Apologies for that, Your Honor.
It's okay.
Rule 65.2, entitled Formulation of Rules and Regulations. In formulating rules and regulations, the DA, BFAR, shall observe these principles. Letter A, the regulation shall be based on scientific studies. In the conduct of scientific studies, stakeholders in the affected regions shall be informed of the conduct of the study, its duration, and the experts who will conduct the same. The stakeholder may nominate their own scientists to participate in the study or will be given the chance to provide comments on the scientists who will conduct the study. Letter B, the consultation shall be conducted in all affected regions as may be practicable, taking into consideration the safety and accessibility of the venue to the stakeholders. Letter C, just two more letters, Your Honor. Stakeholders shall be given at least 15 days prior notice of the date and venue of the consultation, including the subject matter of the proposed regulation. The notice shall be published in a newspaper of general circulation in the region where feasible. And letter D, lastly, the proposed regulations shall be made publicly available at the BIFAR website and BIFAR regional offices at least 7 days prior to the consultation. That's it, Justice.
Thank you for that. How did you know that the BIFAR did not comply with these rules?
In the lower court, Your Honor, during the trial, they admitted, Your Honor, through their witness, Attorney Benjamin Tabios Jr., that in the formulation of their regulation, they should comply with 65.2. But when he was confronted on whether there was scientific basis, a scientific study conducted, he admitted, he testified that there was none. And then later on, Your Honor, please, he said that actually the scientific study is the 2006 UN report. When he was questioned about the 2006 UN report, Your Honor, he said that he admitted that this was not presented actually to the stakeholders in any of their meetings, Your Honor. And so, and the admission went on and on, Your Honor.
All right. When the government chooses VMS, okay, as the means to monitor the illegal activities of a fishing vessel and saying that it is the quickest means and it was on real time and it's also the quickest means by which the government is informed of any illegal activities so that the government can also quickly respond. All right. You are challenging this for being non-scientific. Yes?
Yes, Your
Yes.
Honor. Yes, Your Honor. Because
But,
we were...
all right. So And you have data to support your conclusion that this is not scientific.
It's that scientific. Your Honor, actually, we don't know what will be the function of that, because
You do not know, but because you do not know, you're concluding that it is not scientific.
No, we were not confronted, Your Honor, before the formulation of this FAO 266. We were not given the chance, than the fishing companies, Your Honor.
Yes.
They were not given the chance to comment or check whether it is efficient, effective, or on what are the safety measures. They were never confronted with that, Your Honor.
All right. Now, with respect to your apprehension, I think I was listening to your responses and to the questioning by my colleagues. I concluded that your objection is really hinged on your apprehension, if not suspicion, that the data that will be generated by the BMS will be leaked by the government.
That's one of the apprehensions, Your Honor.
Yes. But you cannot, that's an apprehension, right? All right. But we also have the presumption of regularity in the performance of official functions. Is mere apprehension or even suspicion enough to refute or overthrow the presumption of regularity?
Your Honor, aside from that apprehension, Your Honor, we are alleging that precisely there was a violation of the constitutional rights already of the respondents, their constitutional rights to due process, Your Honor, in the formulation of this FAO 266. So, Your Honor, that in itself negates the presumption of regularity of this FAO 266, Your
All
Honor.
right. We'll go to that later, and we will also ask the Solicitor General to respond to this supposed procedural infirmity. Now, I'd like to ask a question regarding trade secret. How would you differentiate trade secret in the fishing industry from trade secrets in other industries? For example, the food and beverage industry or technology like Samsung or Apple.
Your Honor, trade secrets, say in the food industry, it would pertain, it may include, it may include the trade secret in the formulation of the particular recipe. Say, for example, Your Honor, the Hainanese rice. Okay, it's simple that it is rice, but the formulation as to how to make that Hainanese rice is
A trade
secret of the owner of that business.
Yes.
And he cannot be compelled to disclose that.
How about in the seas,
Okay.
in the waters?
In the seas, Your
What is the trade secret there?
Your Honor, the respondents in this case is engaged in capture fisheries. The trade secret there, Your Honor, the most vital part of the trade secret is the location of the fishing spot at that particular time and the kind of fish to be caught and the volume. At that very moment, Your Honor, that is most crucial to them.
Yes, but the government owns the waters. And it is only because of the liberality and generosity of the government that you are allowed to be on the seas. All right. So
Yes.
where does your trade secret come in?
Madam Justice, our trade secret comes in it being property, the property of the fishing companies, and that as property, Your Honor, it's entitled to be protected by our Constitution.
The
as stated.
location is your property.
No, Your Honor. The the knowledge of the information, Your Honor.
The knowledge of the information of what? Where
Of
the
the
fish
location. Yes.
is bountiful?
Yes, Your Honor.
Yes,
Among
and
others,
the government has no right to know that. Even though the government is the owner of all the waters and everything found in the waters.
it is our submission, Your Honor, that the government should protect that particular right of the fishing vessels with respect to their trade secrets, because that is their property and they should not be deprived of that without due process.
Yes. How about the conservation and protection of the waters and natural resources? Is that not more paramount than trade secret?
Your Honor, it's been held that the Bill of Rights has a primordial position when it comes to being compared with other government rights provided in the Constitution. So that's why, Your Honor,
Yes,
it
but
needs
we
to be protected.
speak here of the welfare of the people of the Philippines in general, and the police power of the state to protect the life of the Filipino people and to protect its own property, which is the waters of the Philippines. Is that not more paramount than your business interest?
Your Honor, of course, the government, being the owner of the sea and of these resources, has the power to regulate. But again, it is subject to its observance of the fundamental constitutional rights of.
Yes, so where there is a clash, and the clash is irreconcilable, which should prevail?
We submit, Your Honor, that it should be the Bill of Rights that should be repealed, Your Honor.
Doesn't,
right.
isn't the Bill of Rights subject to the police power of the state?
Yes, Your Honor.
As you can see, all the provisions in the Bill of Rights have exceptions. And the exception would always partake of protection
Yes, Your Honor.
for the people and the welfare of the people.
We submit, Your Honor. We agree, Your Honor. But if I may add also, Your Honor, in the exercise of the government to impose its right of ownership over the resources, it should also take into consideration other constitutional
Yes,
provisions.
Correct. But you are just a licensee, correct? And
Yes,
a
Your Honor.
license is it is not a right. It is actually withdrawable by the state, being the giver. And it is always subject to limitations. And the limitation being the police power of the state, especially when the common good, the good of the people is at stake. All right. Now, you are also faulting FAO 266. Correct me if I'm wrong, because your position is that it is an all-in-one administrative order. It's not just focus on the BMS installation to regulate, my fishing involving migratory fish, but it also affects non-migratory fish. But according to the Solgen, it is a consolidation of all other issuances, preceding issuances, as well as addressing not only our international commitment, but also our mandate under municipal laws. Okay. Are you objecting to the consolidation into one of all these prior issuances and subsequent issuances of BFAR?
Your Honor, we're objecting to the issuance of this FAO. In particular, that it contravenes the Fisheries Code. FAO 266 imposes the installation of the VMS on all fishing vessels fishing in Philippine waters,
Yes.
as well as this Philippine flag distant water fishing
All right.
vessels. Now, Your Honor, the Fisheries Code in Section 14, it only provides, Your Honor, for a monitoring, control, and surveillance of fishing in Philippine waters, and monitoring, control, and surveillance of Philippine flag distant water fishing. Two aspects, Your Honor. Now, this we have to read in conjunction with Section 119. Because in Section 119, Your Honor, there is no mention of electronic reporting system as being imposed on FAO 266.
Yes. So
There is-
we go back to the choice of the government in implementing not only its international commitment, but its constitutional commitment to protect and conserve the use of the waters and everything found therein. Now, would you agree that the BFAR's mandate is not limited to the protection of migratory fish alone, but extends to every species in our waters? And even in the international waters within the ECZ and the ECZs of other countries where we are allowed access. Yes.
BFAR has
That
mandate. Yeah.
Mandate.
Yes, Your
All right. That's all, Mr. Counsel. Thank you. Were you my student? Unfortunately.
Unfortunately, no, Your Honor, but my
But
wife.
yes, Mia, Attorney Mia. I know her.
But I see you always in the faculty.
Yeah, I also saw you always. Thank you.
Thank you, Madam Justice.
Mr. Solicitor General.
Good afternoon, Your Honor.
The Soldier was not my student, by the way. Okay.
I'm older, Your Honor.
And the Soldier came here in full force. Okay, I can see some of the brilliant minds in the OSG around. Mr. Solicitor General, are you aware of the currently pending case before the United States the Supreme Court United States involving exactly the same issue now before us?
Quite unfortunately, not,
Yes.
Your Honor.
So please take note of Mexican Gulf Fishing Company versus National Oceanic and Atmospheric Administration. Case number 22-30105. All right? What happened in this case, okay, was exactly what happened in that case. And also in that case, the Court of Appeals already struck down the same issuance by the government of the United States as unconstitutional. And now it's being reviewed by the Supreme Court, just like us. We're reviewing it right now. Maybe you could also look into that case. Same with you.
We will, Your Honor.
Yes, please. Last time you mentioned that the BFAR has access to real-time locations of all vessels traversing Philippine waters. All right? Some are represented as trapezoids, dots, arrows, etc. That's why you can see if any of these vessels enter into prohibited areas. Can you state examples of locations in our municipal waters where fishing vessels are prohibited from performing fishing activities? Otherwise, there will be IUUF.
Your Honor, there are certain marine protected areas where access is restricted. There are also, from time to time, closed fishing areas where access is prohibited, maybe for the reason that it is the season for spawning or for rehabilitating the fish stock.
All right,
in,
those who
restricted
prohibit
areas.
the no entry zone, are they penalized? Are they sanctioned?
Definitely, Your Honor, if they have been observed to be violating the provisions on illegal fishing, then under the IUUF law, there is a corresponding penalty once the violator has been convicted.
All right. And you also mentioned last time that one of the requirements under FAO 266 is that the VMS transponder must be turned on 24/7 while they are fishing in municipal waters. That's correct?
Not only in municipal waters,
And even
but
in-
every time that the vessel is active.
All right. So if, for instance, one of the vessels decides to turn off its transponder and subsequently proceeds to a prohibited or protected area and catch protected species of fish, how then would the BFAR be able to find out that said vessel actually committed IUUF?
First of all, Your Honor, the device, the transceiver, is supposed to be tamper-proof. It's supposed to be sealed in a package that will not allow any tampering.
All right.
Number two, Your Honor, assuming that some wise guys are able to intervene with the operations of this device, that constitutes a criminal act under the IUUF law of 2015. Your
All
Honor.
right.
And number three, if I may
Yes,
add,
please.
Your Honor, that may still be observed by the BFARM monitoring system, even in the absence of a VMS. Because apparently some vessels are equipped with what is called the Automatic Identification System, AIS. So even without any device, as a matter of fact, Your Honor, in the BFARM monitor, even without any device, there would be faint representations of, let's say, vessels doing fishing in municipal waters. When they use, for example, super lights, this would be perceived faintly in the monitoring screens of the BFAR. And BFAR would be able to communicate that information right away to the law enforcement agencies like probably the Philippine Coast Guard or the PNP Maritime Group for apprehension.
Yes. Is there some, thank you. Is there some sharing, assistance or sharing of data between BFAR and the Philippine Coast Guard for purposes of conserving and managing our fisheries resources through the use of VMS?
Not necessarily through the use of the VMS. Your Honor, the Philippine Coast Guard provides the BFAR with data on apprehensions in Philippine waters. But there is no qualification that the apprehensions were done with the help of the VMS. That is why we are suggesting to the BFAR to make representations with the Philippine Coast Guard or the PNP Maritime Group that whenever these agencies report apprehensions regarding violations of IUUF, they indicate also whether the apprehension was with the assistance of the VMS.
All right. The counsel for the respondents was complaining that the right of his clients to due process was violated because they were not informed of the formulation of the rules and regulations, and that there was no scientific basis for the installation of the VMS. Any comment on that, Mr. Solicitor General?
Your Honor, that is not true. several regional consultations had been held before the issuance of FAO 266. As a matter of fact, the private respondents here participated in those consultations. And commercial vessel owners are members of the National Fisheries and Aquatic Resources Council, an interagency body where the private sector is duly represented. All of these consultations happened before the issuance of FAO 266. Now, as to the absence of scientific basis, Your Honor, while admittedly the BFAR did not conduct its own scientific studies, they relied on the report of an expert's consultation on the various vessel monitoring measures, including the VMS, held in Rome in 2006. And let me add, Your Honor, that since the Philippines is a member of various regional fisheries management organizations, which all impose the requirement of using VMS as part of their conservation efforts, that would be enough convincing or influencing factor for the BFAR to adopt the same system of VMS for the Philippine government. And in this regard, Your Honor, let me mention that the Philippine government subscribes to the principle, to the precautionary principle, which states that in the absence of complete and scientific basis, the better or more prudent action would be to take the necessary measures for the protection of the environment, notwithstanding the insufficiency or completeness of scientific studies. It is better to err on the side of prudence.
Yes, but according to the respondents, the scientific study that the government has relied upon is no longer updated because it was done way back 2006, and so many developments have already happened. What is your take on that?
Your Honor, there has not been any development since 2006 that would disprove the ineffectivity of the VMS. As a matter of fact, in the many years that followed, many regional fisheries management organizations adopted the very same report that came about in 2006 from the Rome consultation among VMM experts. So nothing, Your Honor, during all these years that would tend to show that the VMS is an ineffective system.
All right. The respondents are complaining that they were never informed, they were never involved. My question is in the formulation of this FAO 266. My question is the non-involvement of a sector of the stakeholders, will it affect the validity of FAO 266 on ground of lack of due process?
First of all, Your Honor, as I mentioned earlier, it is not true that the private sector, more particularly the commercial fishing operators, were not involved in these consultations.
So
that is a fact.
Yes, so the respondents, they just did not know.
They're
That's
aware.
why they were not able to attend.
First of all, they were aware because the consultations were published.
All right. Maybe they did not read the papers.
And besides, they actually attended.
They actually attended.
Yes,
All
Your Honor.
right.
On the matter of whether it will affect validity, Your Honor, in my opinion, the participation, even if there was not, while it may affect probably the sufficiency of the consultations, it will not affect the validity of any action that was eventually taken.
All right. Now, if we are found wanting by the European Union's IUUF policy, okay, what penalties are awaiting us?
If they make good on their threat, the worst that could happen would be a ban on Philippine exports of fisheries products to the European community, Your Honor.
All right. You spoke of the SRT Marine Systems being just a provider of the gadget itself. All right. So it does not have any access to any data that would be or has been collected by the VMS itself.
No.
Yes.
It will-
Is that correct?
Yes, Your
Yes,
Honor. Yeah,
because this agency is only got involved as a provider.
of the equipment.
Is that correct? Now, how about in the after purchase warranty? For example, if something goes wrong with the VMS, who will repair the VMS?
Your Honor, if the contract provides for a warranty period, then I suppose that
Yes.
SRT Marine will have to do the necessary repairs
Repair,
or replacement.
yes, which equipment already contains the data that it has captured so far?
Your Honor, the encrypted data had already been transmitted to the BFAR where it is stored.
So it is safe, even if it does an after purchase service, it will still not be able to get hold of the confidential data captured by the VMS.
That is my understanding, Your Honor, but on the technical aspects, I wouldn't really be able to say with definiteness.
That's all, Mr. Solicitor General. Thank you.
Thank you, Your Honor.
Thank you, Justice Javier. Justice Ben Kagiwa will conduct his interpellation.
Thank you, Chief. In the interest of time, since it's almost 5 o'clock, I ask that microphones be given to each of you so that I can just ask directly. You don't have to go to the podium. From the get-go, I will tell you that I am confused. I am so confused that I need to ask you real time what your positions are. So let me begin by going into procedure. You, respondent, as plaintiff below, you filed this case as an environmental case, correct?
Hello. Hello. Good afternoon, Your Honor. Yes, Your Honor.
So there is no more issue on whether or not this is an environmental case or not. Correct?
Correct, Your Honor.
I'm going into the point raised by the Solicitor General in the last hearing where he asks the court for a general restraining order to tell all courts that no RTC can issue a writ of preliminary injunction in or TRO. That was the prayer of the Solicitor General before, correct?
Yes, Your Honor.
All right. So let me go there. Section 134 of the Fisheries Code, RA 8550, as amended by RA 10654, states, and I quote, "No injunction or restraining order from the municipal trial courts and regional trial courts shall lie against the department and BIFAR upon the ex parte motion or petition filed by any person or entity in the exercise by the department and BIFAR of its regulatory functions in support of the implementation of this code, close quote. That's in the law, section 134 of the Fisheries Code. This appears to me as possibly can be interpreted to mean that a lower court can issue a TRO so long as it is not ex parte. Am I correct, Mr. Solicitor General?
It seems, Your Honor, but I do not agree
With the law?
with the applicability of Article 134 to the petition for declaratory relief.
All right,
If you may,
hold on.
okay.
I will go to that. The Supreme Court has issued rules of procedure for environmental cases. Part 2, Rule 2, Section 10 says, except the Supreme Court, no court can issue a TRO or writ of preliminary injunction against lawful actions of government agencies that enforce environmental laws or prevent violations thereof. Are we agreed that that's what the rule says?
Agreed, Your Honor.
Yes, Your
So there seems to be a conflict between the law and the rules set by the Supreme Court. Or is there?
No, Your Honor, there is no conflict.
Why is there no conflict? Mr.
Article 134, Your Honor, of the Fisheries Code, where it would seem that if the application for restraining order or injunction, preliminary injunction, is not ex parte, then it would appear that the trial court may in fact issue injunctive relief. But let's take a look at where Article 134 belongs. It belongs to a certain chapter.
Yes.
And the heading of that chapter is administrative adjudication.
Regulatory functions.
Yes, Your Honor. And therefore, Articles 130, 131, 133, 134, 135 are all in the context of an administrative adjudication.
I agree with you. In fact, I think the distinction to make is that if my cause of action is against the regulatory functions of the BIFAR, then a TRO can be issued by a court so long as it is not ex parte. But using the language of the rules of the Supreme Court, if what is involved is the enforcement of environmental laws or the prevention of violations thereof, it is the rules of court that will apply. Are we agreeable to that?
I agree, Your Honor.
Counsel, in this particular case, what is the nature of this case? Does it involve the exercise of the regulatory functions of the BIFAR? Or is it an action to enforce environmental laws? Since the private respondent was the one who filed the petition, how do you characterize your own petition, counsel?
Your Honor. Good afternoon, Your Honor.
Good afternoon.
Your Honor, we consider the case as one involving the regulatory aspect of BIFAR.
Because what you seek to annul in your petition is an FAO,
Is an FAO, is a
which is
regulation.
regulatory in nature.
Yes, Your Honor.
However, the Solicitor General, I think, will disagree with you. Or do you? Mr. Solicitor General, you can stand in the podium para hindi na tayo maghiraman ng ano.
Your Honor, it appears to be both because the regulation was also for the enforcement of an environmental law. So to that extent, the rules of procedure promulgated by the Supreme Court would apply.
Okay. Okay, another procedural question. Again, this is all meant to clarify confusing ideas in my head. With respect to the proposed intervenor, did they offer any argument that you, the Office of the Solicitor General, is not putting before the court? Any legal argument that they have that you are not arguing? Is there any?
They're arguing on the basis of constitutional provisions, which are the same
The same.
as the position of the OSG.
All right. So technically, listening to you is listening to them.
I think so, Your Honor.
Okay, thank you.
Except for the procedural matters.
All right. The decision of the lower court here quoted the case of Air Philippines versus Penswell in defining a trade secret. And I quote, let me quote, any formula, pattern, device, or compilation of information that, number 1, is used in one's business, and 2, gives the employer an opportunity to obtain an advantage over competitors who do not possess the information. That is the definition of the court in the case of Air Philippines. Are we taking issue with that definition?
No, Your Honor.
Okay.
No, Your Honor.
So the use of the phrase compilation of information can be construed as trade secrets, correct?
Yes, Your Honor.
All right. Discovered fishing grounds of fishing vessel operators having a compilation of information on where the most abundant fish are, that can be trade secrets, correct?
Correct, Your Honor.
Mr. Solicitor General?
Yes, but ephemeral.
But ephemeral.
Ephemeral in the sense that it's a trade secret for as long as it remains secret.
That's correct. But it's a compilation of information. Longitude, latitude, depth, time of day, whether there's sun or there's moon, that's their information.
Yes, Your Honor, but not invocable against the government.
Okay, that's where we go. So in other words, you recognize, Mr. Solicitor General, you recognize that there are trade secrets. In this particular case, you're saying that it cannot be invoked against the government.
Yes, Your Honor.
All right. In section 155 of the IRR of the Fisheries Code, it states that the Department of Agriculture shall take such measures as may be necessary in order to protect trade, industrial, and policy information of Filipino fisherfolk, fisheries owners, operators, et al., when disclosure of such information will injure the competitiveness or viability of domestic fisheries. That is section 155. Mr.
Yes, Your Honor.
Solicitor General,
Yes, Your Honor.
isn't this a recognition that the government is called upon by the Fisheries Code to respect or at least take measures to protect trade information?
Yes, Your Honor, that's correct.
So is it correct for me to say that what this case presents is a weighing of rights between the protection of trade secrets versus the right of the state to monitor? Is that a good way of characterizing what is the current issue before the court?
From the point of view of the respondents, it would appear to be so, but not from the point of view of the government, Your Honor.
In the point of,
Because the government is not a competitor of the private respondents here.
so in other words, you will override or disregard their trade secrets so long as the purpose of government is more paramount.
That is true, but we are not overriding, Your Honor, the trade secrets being protected by the private respondents, because there are provisions of the law that makes it criminal if information gathered by the government is leaked out. This is characterized as sensitive technical information.
Yes,
for
but
which any violation would be tantamount.
correct. But counsel, is that a real protection when the trade secret is already out? Isn't the protection for a trade secret precisely to keep it secret? Because if you're just saying, I can always sue the person who leaked it, the horse is out of the barn already.
But that is what the government is precisely doing, Your Honor. All the information that is collected through the VMS system is stored and kept confidentially by the Bureau of Fisheries and Aquatic Resources. It's not made accessible to anyone. It is only accessible to the owner of the vessel which provided the information, but to no one else.
All right. I understand this underwent trial, correct?
Declaratory relief, Your Honor.
Yes, but there was hearing by the lower court
Yes, Your Honor.
and witnesses were presented
Yes, Your Honor.
and cross-examined.
Yes, Your Honor.
And in the order of the court, or should I say the decision, he makes mention of certain evidence, excuse me, that shows that the people who were manning the portals where the information was coming in were not even employees of BIFAR or did not have non-disclosure agreements with them. That is a matter of evidence before the lower court. Am I wrong?
I think that was part of the testimonial evidence, Your Honor.
So in other words, as far as the state is concerned, you are insisting on the VMS over and above the trade secrets of private respondents, plaintiffs below, even if your controls are not secure.
Your Honor, even assuming that these controls were not available at the time, it doesn't mean that those controls cannot be done now.
Okay. But you do agree that as far as this appeal is concerned, we are looking at the evidence presented in the lower court, right?
Yes, Your Honor, but this is also a petition for certiorari. It's a consolidated petition, Your Honor.
Okay. Just a few more questions. During the interpellation of Justice Ami, she talked about illegal, unauthorized, what's the other U?
Unregulated.
Unregulated. And she was saying that, how does BIFAR monitor where vessels go? And you said, in fact, you don't need the VMS for that. You have the BIFAR monitoring system, and you have the AI system automatic identification system. Did I hear that correctly?
Yes, Your Honor.
Okay. In other words, if a vessel is to go to a fishing ground that is prohibited, or if it were to go to a fishing ground that has been determined to be overfished, these systems already will tell BIFAR that these ships have gone to those areas, correct?
Only if those vessels had those equipment, Your Honor. If they did not have those equipment, BIFAR may not be able to detect them either.
Okay, but BIFAR, under its regulatory functions, can require these systems, correct? In the same manner, you're saying that the BIFAR can require the VMS.
Yes, Your Honor. Precisely, the BIFAR is requiring the VMS rather than something else.
Yes, but
That's their choice.
But these systems work, correct?
Only if the vessels had them.
Yes, and the BIFAR can require them to have them, correct?
Yes, it's a matter of choice. The VMS was the choice.
Yes, but see, the problem is, the problem for me and my confusion is that the VMS asks for something more. It asks that real-time information is uploaded by the fishing boat at the time it makes a catch, correct?
Yes, Your Honor.
Therefore, even if that vessel is not in a prohibited area, it's not in an overfished area, you're requiring that,
Yes, Your Honor.
correct?
Yes.
And that's exactly, I think, their bone of contention. Why should that be required when that will give away their position and therefore give away their trade secrets? When the government can, in fact, already monitor IUU, IUUF by virtue of these systems that you just mentioned.
Your Honor, the purpose of the VMS is not only to detect IUUF. It is also for the purpose of gathering all necessary scientific data as to catch which areas are overfished, and so forth and so on. So that function of collating data would be very useful for the BFAR in managing its conservation programs.
And that's the one that's not clear to me. So if you can include in your memorandum a description exactly of how the VMS is able to get such data that you say is important to BFAR for BFAR to function as BFAR. If you can add that data.
Yes, Your Honor.
All right. Can I ask, I had a form to be flashed. Sorry. Sorry, my eyes are bad. Prior to VMS, this was the BFAR prescribed fish catch report and log sheet, correct? Or is it still being used today? Can I ask BFAR? It's in the screen.
Yes, sir. Yes, Your Honor, we are still using it at this time.
All right. Can I get confirmation from the respondents that your clients actually fill in this information?
Yes, Your Honor.
Your Honor, to clarify, that form is for highly migratory species, Your Honor.
All right. But you have your own form for pelagic fishes, correct? And is it more or less the same?
Your Honor, may I?
Please.
Your Honor, it is small, but it has more details, Your Honor.
Can I borrow? Apparently I
may
have the wrong
approach.
annex. Thank you. You're right, it's small. Based on this is a report that your client, the fishing company, would submit once it reaches the port to unload its catch. Correct?
Correct, Your Honor.
And it indicates the longitude and latitude of where your activities occurred. Correct?
Your Honor, yes, the longitude, latitude, but I've been informed, Your Honor, that it's submitted quarterly.
Quarterly.
Yes, Your Honor.
Not when you deliver the catch. It's not on a daily basis.
One, Your Honor.
Not this one.
Yes, Your Honor.
But there's another form.
There's a form that their carriers submit to unloading ports. Your
Unloading
Honor.
ports.
Yes, Your Honor.
Correct. And do they also indicate the way these forms indicate the kind of fish that has been caught?
Yes, Your Honor.
So it says skipjack, yellowfin, big eye, other species. There's even tuna here.
Yes, Your Honor.
So in other words, a fishing vessel goes out to sea, catches fish, and then brings it back to port and reports it through these documents.
Yes, Your Honor.
And the government or the port, acting on behalf of the government, can now see with its own eyes whether or not, oo nga, yellowfish, tuna, etc., the gross tonnage is this much, etc. Tama yung report,
Yes, Your Honor.
correct?
Yes, Your Honor. They can
So-
verify.
So for purposes of determining only what has been caught, these documents already supply that.
Yes, Your Honor.
Is this the same information that is required to be transmitted by the ERS? ERS ba?
ERS, yes, Your
ERS?
Honor.
Is it the same information?
It's the same information, Your Honor.
So it's exactly the same information.
Yes, Your Honor.
And that information will go to the government
But not in-
before, not real time. Now, because of this, it's real time.
Yes, Your Honor. That's
Okay. Counsel, not that I'm telling you to do this, but is it possible for a fishing operator to stay in one place, fish there, go to another place, and that's the only time he inputs the information of what fish he caught in another place? Is that possible?
If that will not, Your Honor, there is a requirement in FAO 266 that in a day they should at least report one catch per day.
Okay.
So they are required to report within 24 hours.
Correct. So in my scenario, where I go to my fishing ground here, kasi as you said, malaki yung dagat, no? Malaki rin ang fishing ground nyo. So I go to one part of the fishing ground, I do my catching of fish there. I go to another part of the fishing ground, and that's where I input the information in the ERS. Pwede kong gawin yun, di ba?
May, Your Honor.
And that information is not inaccurate. It is the same amount of fish.
Yes, Your Honor.
Correct?
Because they can verify, Your Honor.
It will just be inaccurate on where it is. As to,
To the location, Your Honor.
correct?
Yes.
Therefore, it seems to me that the ERS is forcing you to lie to protect your trade secret. Tama ba ako?
Yes, Your Honor.
And that's why you filed the suit, because
Don't
you
want to
don't
lie.
want to lie.
Yes, Your Honor.
You'd rather that we make sure that government gets its ability to monitor, but not at your expense.
Yes, Your Honor.
That's your position, correct?
Yes, Your Honor.
So it all boils down to ano bang nagagawa ng VMS for the government as far as monitoring is concerned na hindi nagagawa ng current systems, assuming those current systems are mandated by BIFAR. Because real-time uploading of data reveals your trade secrets.
Your Honor.
Tama ba ang pag-crystallize ko ng issues nyo?
Yes, Your Honor.
All right.
Tama po.
That's all. Thank you.
Thank you, Justice Kagiwa. As such, the Onen will conduct his interpellation.
Thank you, Chief. Can I ask the counsel of the respondents to take the podium? Thank you.
Good afternoon,
Congratulations, you are doing well so
Thank you.
far. But after my questioning, I do not know.
But thank you
Yes,
very
and,
much, Justice.
Since this is your first time in the court, I'll ask you to get to the podium so that you will have more memories of arguing before
I
us.
appreciate, Your Honor. Thank you.
After the heated interpellation of Justice Ben Kagiwa. So I will be kind. You mentioned a while ago that the unregistered, not the registered vessels will most likely violate. Is that correct?
Yes, yes, Your Honor.
Okay. And you did mention a while ago about a case in the Ombudsman where you were not privy.
Yes, Your Honor.
Okay. How long have you been counsel for Royal Fishing Corporation?
Since maybe 2011 onwards, Your Honor.
Okay. Are you familiar with FD Anastasia? It is a ship registered as BIFAR registry number 0000417. The registered company or owner is Royal Fishing Corporation. You affirm?
I don't exactly know the names of their vessels, Your Honor.
In any case, from sources, open source, we found out that Royal Fishing vessel was apprehended on September 18, 2021 for illegal fishing activities. Would you know this?
I've heard of it, Your Honor.
Yes, and this was for the use of super lights, which is illegal already, correct?
Yes, Your Honor.
And it was actually fined, and I guess the fine was paid 30,000.
I'm not aware of that, Your
Okay.
Honor.
You are counsel of RBL Fishing.
Yes, Your Honor.
Also, how long have you been counsel?
Recently only, Your Honor.
Okay. Do you recall your statement on September 26, 2023, that your client is not in the business of exporting tuna? Do you stand by that?
Yeah, yes, Your Honor.
You stand by that?
Yes, Your Honor.
And you are sure that your client, it's a fishing corporation that sells, and therefore they have a website, and they have the truth in their website, correct?
Yes, Your Honor. Okay, if I may clarify, Your Honor, please. They have stopped their tuna operation way before, Your Honor, but now they're engaged only in galunggong.
Okay, so here is the website of RBL Fishing. Present, access today. And there, the main title page states that as a commercial deep sea fishing company, RBL is engaged in domestic and international Persian, I hope I got that correctly, fishing that primarily catches mackerel, sardine, skipjack, and tuna, correct?
Correct, Your Honor.
Migratory species.
Correct, Your Honor.
Okay. The first two aforementioned are sold in Navotas, okay, known as the fishing capital of the Philippines,
Yes.
while the latter are mainly sold to canning factories around the globe. Is that correct?
Yes, Your Honor.
Okay. In the website,
In the website,
Okay.
not updated, Your Honor.
not updated.
Yes, Your Honor.
Okay. On your honor as a lawyer.
Yes, Your Honor.
Okay. And in fact, that they have been starting tuna operations in Indonesia and Papua New Guinea as early as 1990. Is that correct?
That I'm aware, Your Honor.
Okay. In Indonesia, they require VMS.
Yes, Your Honor.
Exactly the same.
Yes.
In fact, in Indonesia, not only do they require VMS, they publish publicly
Yes, Your
the
Honor.
results of their VMS insofar as the location is concerned.
Yes, Your Honor.
That's their call, correct?
Yes, yes.
So in Indonesia, is your client complying with VMS?
Yes, Your Honor. It's
So-
a requirement there, Your Honor.
Yes, so they can comply with the requirement of VMS in Indonesia. Thailand also requires VMS, but you do not wish it to be in the Philippines, correct?
Because they have no choice there, Your Honor.
Yes, but you are to comply with VMS in other countries, but you want in the Philippines that the BFAR will be, well, not totally blind, but will have a disadvantage in terms of digitalization, automation, data analytics, compared with our neighboring countries, correct? That will be the net result, correct?
Yes, Your Honor.
In fact, it will be more difficult in comparison to what China has. China has even more sophisticated data analytics because it requires every country that goes within their stated territory, and their Coast Guard is everywhere, to comply with even a more sophisticated data analytics system, correct?
Yes, Your Honor.
So where if the Supreme Court of the Republic of the Philippines would nullify our VMS, then we will be at a disadvantage compared with the other countries informing their fishers with respect to conservation, management, and even commercial fishing. That could be the net effect, correct?
It would appear
That's
to be,
possible.
Your
Okay.
Honor.
Now, are you aware of the fishing vessels of RBL, namely Fishing Bangka Mona Linda 68, Morning Glory 19, Mayfair 21, and Morning Glory 27? Not really.
Apology, Your Honor. I have not memorized.
So it was caught violating Municipal Ordinance number 139 for fishing 7.3 nautical miles from the shores of Barangay Tinintinan, which is still municipal waters, correct?
If I may
You can consult. So if this was the case, if it is true, I'm just saying if, then so much for the need for the monitoring GPS real time, because that also helps in determining whether a commercial trawler is fishing in municipal waters, correct?
It will just be redundant, Your Honor,
Yes.
the
But
VMS.
in this particular case, in fact, registered owners, registered vessels can violate. Right?
Agree, Your Honor.
Yes. And it is not only unregistered municipal vessels that can violate.
Yes, Your Honor.
Yes. And therefore, it is the state's duty to make sure that our fisheries laws, our need to conserve resources is actually protected, correct?
Correct, Your Honor.
Okay. Thank you, Counsel, for being honest. Can I ask the Solgen? Solgen,
Good afternoon, Your
this
Honor.
current administration is all for open governance, correct?
Yes, Your Honor.
As a matter of fact, we encountered the entire executive department almost. In fact, the Supreme Court sent 7 or 8 justices to that conference in Tallinn in Estonia with respect to open governance, correct?
Yes, Your Honor.
Yes, and open governance requires digitalization, a way of translating paper into digital so that we can automate, so that we reduce human intervention, so as to reduce corruption and other rent-seeking behavior, as well as the use of all of that for data analytics, correct?
Correct, Your Honor.
Yes. And this push towards the use of a VMS system is also a way that we comply with open governance, correct?
Perfectly correct, Your Honor.
Okay, now, our premise in looking at our ecology, should it be that we should allow competition because there are so many resources available out there? Or should we start with the premise that there is a reality, not only of climate change, but there is already a lack of fishing resources. Competition destroys the ecology. Should that be our premise?
Competition does not necessarily result, Your Honor, in the diminution of our resources.
Yes,
It's
but
a question of management.
yes, management, and that shouldn't our premise be that the planet is in crisis already? In terms of climate change, its effect on the salination of waters, the effects of fishes, the effect of unbridled IUUF in terms of the food security of our own country.
I would say, Your Honor, that we are in a very unusual situation, not normal in the sense that we have known the situation many years back, but I'm not prepared to say that the situation is critical.
Yes. And I find it strange that you are now in the petitioner side, because when I was a young lawyer arguing a mining case on the basis of ecology, the Solgen was on the other side. Now you are on the side of conservation management through the VMS, correct, Counsel?
Yes, Your Honor.
Yes, but you were not the Solgen at that time. So let's look at the concept of property and whether fishes and whether information on fishes can actually be a property right covered by this amorphous, non-statutory concept called trade secrets. By the way, is trade secret a statutory text? Or is it judgment? I mean, patent is, copyright is,
Yes.
utility model is, geographical indicator is, but trade secret.
Trade secrets are not patentable,
Yes.
in my opinion, Your Honor,
Yes.
because
So,
they're ephemeral.
in fact, it's amorphous, correct?
Yes.
Yes. And the definition given by that single Supreme Court decision has been qualified by another Supreme Court decision I will mention later, correct? In terms of how or who has the burden of showing it, correct? Yes. Now, let's look at what property could be. Because are you familiar with Section 2, Article 12 of the Constitution?
Yes, Your Honor.
Yes. All lands of the public domain,
Yes.
fisheries, flora and fauna are owned by the state, correct?
Yes, Your Honor.
Specific mention, fisheries, owned by the state, correct? And it says that its exploitation, development, and utilization can only be done with the state doing it directly or through co-production, etc.
Yes, Your Honor.
Yes, that means that there is an implicit, in fact, there is even another provision. The nation's marine wealth in archipelagic waters, etc., reserve its use and enjoyment exclusively to Filipino citizens, correct?
Yes, Your Honor.
Yes. And there is implicit in that a kind of perspective on things which cannot be property per se, but things which Filipino citizens can be given the privilege to exploit, correct?
Exactly, by licensing for one.
Yes, and in fact, there was this new decision from the Supreme Court, decided en banc, which clarified that Regalian doctrine, parents patriae, all come together in what we now consider as a stewardship perspective, known as the public trust doctrine. Are you familiar with that?
I've heard about it, Your Honor.
Yes. And do you know the ponente of that case? He's on my right. And this is in the case of Maynilad. In fact, in that specific case, it said that this academic literature further imparts that part of this consciousness involves restoring the view of public and state ownership of certain natural resources that can benefit all, correct?
Correct.
So
Your Honor.
not only the trawlers, the commercial fishers, but likewise how it will affect our future generations as well as the small communities, those that earn 80 pesos a day just by fishing municipal waters. I will ask the intervener later about a particular intervener that has come in and wishes to make their position held. So in other words, there are things which cannot be capable of being property rights because first and foremost, they are within the public trust doctrine. As a matter of fact, there is even this theory of natural resource management whose premise is called the tragedy of commons. You're familiar with that?
I have heard about it.
Yes, this is by Thomas Hardin in 1960, simply saying that when you have a public resource where everyone has access to it, the tendency is that it will result in a suboptimal situation where everyone that comes in will try to exploit it as much as they can, resulting in over-exploitation. As a matter of fact, isn't this what is happening with our fisheries today?
I think so, Your Honor.
Yes. So all of this come together with a constitutional provision which qualifies that particular concept of ownership. Okay, now, of property. Okay.
Yes, Your Honor.
So when you said that you agreed that the information with respect to fishes is really a trade secret, I am surprised. Because the constitutional provision says fisheries owned by the state, it should know where it is, how it grows, and the quality of the fishes, the quantity of the fishes. So the information gathered by the state is really the owner of the state using the public trust doctrine for the community fishers, for the public wanting to buy galunggong, etc., to be able to be protected, correct?
That is why I said that that concept is not invocable against the government, against
Okay.
the state.
And perhaps in your memoranda, you clarify that further, Mr. Solgen, so that we are also clarified. By the way, even if assuming that knowledge of where the fishes are is a property right, even if assuming, isn't there a provision in the Constitution which says that the use of property has a social function?
Yes, Your Honor.
In other words, we are not in a situation like the United States of America that does not have Article 12, Article 13, Article 14, Article 2, correct? Our Constitution looks at property in a different way, right? That
I
the
agree.
property is limited to the public function, and as a matter of fact, Article 2, Section 10, the state, that means us and you, and legislature and BIFAR, shall promote social justice in all phases of national development, correct?
Correct, Your Honor.
Yes. So therefore, there is a difference between fishes, knowledge of where the fish are, and the property right of a car where you attach a GPS, correct?
I
or
agree.
the information on where the car goes and attaching a GPS. That's different.
I agree.
Because the car and the information as to where Mr. Jones went in the United States of America is something which the Supreme Court said is information personal to that person. And the state has no business unless there is a search warrant, correct?
Correct.
Yes. And by the way, that's United States of America, correct?
Yes, Your
Yes. When did we gain our independence from the United States of America, Mr. Soldier?
1946.
Yes. Are we bound by the U.S. Supreme Court?
No,
Can we
of
get
course.
promoted to the U.S. Supreme Court? No, right?
Of course, we're not bound. There.
Yes. And for us to actually quote a U.S. Supreme Court in front of the Philippine Supreme Court, to me, I am offended. Because why not quote the EU or South Africa or some other case? Because we are the highest court of the land. You quote to us our cases, not the U.S. Supreme Court, correct? Yes. Okay. Thank you for affirming that by your silence. By the way, therefore, using fishes, gathering fishes, okay, cannot be done without a license, correct?
Correct, Your Honor.
Yes, and I can start to enumerate here all the laws where we actually say that they need to register, they need to have that license or privilege in order to fish, correct?
Yes, Your Honor.
And that privilege is a privilege from the state. The state can withdraw it, modify it, amend it, correct?
Exactly. Your Honor.
Yes. And in fact, there are Supreme Court cases that do define the concept of a license. For lack of material time, I will not quote many of them by my colleagues sitting here, correct? And probably you can help me try to define that later on, okay? What should be our premise as the Philippine Supreme Court? Should we second guess the premises of the Congress when they come out with the law? Should we re-examine their policy basis in order to be able to say you are wrong? Or should our approach be, when they have determined a particular state of affairs, we give it deference?
It's a very difficult question. Your Honor. Yes,
For
but
example?
unless and until it is very important to go into what transpired in the enactment of a law, I suppose that pursuing the principle of independence of the three branches from each other, then I suppose that in general, the Supreme Court would just have essentially to interpret what the law says, unless it is absolutely necessary to resolve the case.
Can we conclude in the laws that have been passed? I can actually point to several provisions, but in general, due to lack of material time, can we conclude that Congress has already determined that there is a possibility of overfishing happening, not only in municipal waters, but also outside municipal
Yes,
waters?
I guess that is a very good assumption.
Can we conclude that in order to prevent overfishing and in order to monitor other things besides overfishing, Congress has already determined that we should have an effective monitoring, control, and surveillance system, NCS?
I agree, Your Honor.
Can we not conclude that in order to have a monitoring, control, and surveillance system, that there is a necessity to do a vessel monitoring system?
Yes, Your Honor.
Yes. And that this has been effective in various parts of the planet in order to be able to stall or at least delay the effects of illegal, underreported, what is the other U? Unregulated fishing.
Yes, Your Honor, it's practiced globally.
Yes, and therefore, can we not say that that has been the premise for all of these laws, right?
I believe so, Your Honor.
Yes. And for us to ask you to show us the scientific relation between that and this requirement that on board are all of these devices is for us to do what the legislature has actually or has supposedly done, correct?
Not only the legislature, but also other institutions, other countries, other states which have adopted the same thing.
Yes. Okay. On trade secrets, are you familiar with the case Philippine Association Smelting and Refining Corporation versus Lim? 796 Philippines 387 2016.
No, I'm not, Your Honor.
Yes, I did not memorize it. I'm reading it from here, unlike one of my colleagues who can memorize everything. But in that case, this was a conflict between the corporation and the shareholder. And the shareholder was asking information, the corporation was saying trade secret. And in that particular case, the Supreme Court actually said that between the shareholder and the corporation, the shareholder is at a disadvantage. But the shareholder is entitled to know, and therefore it is the burden of the one that's claiming trade secrets to prove in a very detailed manner how the information being asked is a trade secret. Because in the parity of access to information between the shareholder and the corporation, it's the corporation that can hide it, correct?
Correct.
Yes. And by analogy, government, small fishers, okay, trying to know whether there is overfishing done by commercial trawlers, commercial fishers, correct? Can we apply that just in case knowledge to fish where the fishes are is really a trade secret, that it is their burden to actually prove that their processes, as Justice Ricky has said, everything is in the open. How can this be a trade secret? It's their burden to show, correct?
Yes, Your Honor.
Yes, and we cannot create doctrine saying that where a fishing vessel goes is a trade secret. Because when we start to do that, then we hobble the ability of our government to be able to monitor how fishes are being catched and whether in fact there is overfishing, correct?
I agree.
Yes. You cannot determine whether there is overfishing on the basis of one vessel, correct?
Yes.
Yes. But you can do that using artificial intelligence or simply automation by getting information real time from all the vessels as accurately as possible. Therefore, to require them to report every 24 hours, that's reasonable. Buti nga hindi every hour. But every 24 hours, they're catch. That's better than nothing, correct?
Yes, Your Honor.
Yes, and for government to actually know where the fishes are, we cannot send divers all over, correct?
Correct.
We cannot send Bantay Karagatan all over, correct?
Yes, Your Honor.
We cannot send our Coast Guard all over, correct?
Yes.
Certainly, we cannot send our Navy because we lack the ships, correct?
Yes.
And therefore, we are putting in a reasonable requirement on those that are actually present, correct?
Perfectly agree, Your Honor.
Okay, now, the communication from the ship to the satellite, is this encrypted?
Encrypted, Your Honor.
Satellite to
Before.
DFAR, encrypted?
Encrypted.
And as you said, man-in-the-middle approaches are impossible because it's 256-bit encryption, correct?
Yes, Your Honor.
Yes. Can you explain that in your memoranda? I understand that, some of us understand that, but it's better when we write out the case that we actually assure those that are giving data that it is encrypted. Now, anything digital, you need to protect it by cybersecurity, correct?
Yes, Your Honor.
Anything paper, you need to protect it by also, correct?
Yes.
Yes. But unless we move to the digital world, we cannot take advantage of getting all the information to do better conservation management and protection of our resources, correct?
I agree.
Okay. We're not doing it for the commercial trawlers, correct?
Yes.
We are doing it for our people, right?
Yes.
Because when there are no more galunggong wherever, because it's overfished, it is not the ship and the owners that will suffer. They don't eat galunggong, they eat steak. Or perhaps they still eat galunggong. But the ones who will suffer are the municipal fishers because there are no more pelagic species that will go to them and therefore they will catch nothing, correct?
Yes.
Yes. So again, it is not really between a conflict of property rights and policy. This case is all about what this government can do to protect food security, food sovereignty, and the rights of our communities, and of course, environment. Because this is, as you said, both said, an environmental case. Okay.
Correct.
Privacy is a constitutional right, correct?
Yes, Your Honor.
But trade secrets is not the right to privacy immediately, correct?
Yes, Your Honor.
It's a commercial concept.
Yes, true.
Yes, and the right to privacy is different as a constitutional concept, as differentiated from trade secret, correct?
I agree.
As you said a while ago, trade secret is between two commercial actors, right? Right to privacy is between an individual and the state, correct?
Correct.
So therefore, you cannot say that just because it's trade secret, your rights to constitutional privacy is already violated.
I agree.
Yes. Otherwise, we conflate what commercial law says and what constitutional law has created, right?
Yes.
As a matter of fact, the right to privacy is derived from Section 1, Article 3, the right to life, liberty, and property, correct?
Yes. Your
But we've already said, how can this be property
Hmm.
when it is already owned by the state and that we are only giving license for them to fish, correct?
Yes, a privilege. Your Honor.
Maybe you can develop that more so that my mind will be more clearer about the difference between right to privacy as a constitutional right and trade secrets on the other. So we are not doing this because the EU said, correct?
Yes, Your Honor, definitely not.
We are not doing this because there is some other entity out there that said it. Of course, it will benefit our fishers if we can export to the EU, correct?
True.
Because in the EU, they have already required this type of VMS, correct?
Yes, for
Yes.
everyone.
For everyone. Thailand is doing it already, correct?
Yes.
Indonesia is already doing it, right?
Yes.
Okay, now I'll show you a map where you can see dots. Okay, can you flash it? Okay, this is a map from Karagatan Patrol Org, where you can see where at a given point in time, people are fishing or vessels are fishing. Okay, can you see the red dots? Okay, so there are so many red dots that it is almost impossible to say that one of them has a trade secret on location, correct?
Yes, Your Honor.
Because they are clustered. And probably this is what Justice Ricky was saying a while ago. Whatever information, whatever divinity that a company uses in order to find out where the fishes are, whatever scientific knowledge that they have, others also have access to that. And therefore, when you actually look at the map, it's there. That's karagatanpatrol.org. But I understand what BIFAR has are also red dots, correct?
Not only red dots, many other types of representations, Your Honor.
Yes. And the only time that they can locate it is when they decrypt the information to know which vessel is there.
That is correct.
So, in other words, it is not true that there is a unique dot out there, very far away, where they can actually see, oh, ito, they know something that others don't. Moses or Allah talk to them. Or the science that they use is unique to them, correct?
Yes, Your Honor.
Yes. And the truth is that fishers actually follow each other, correct?
Possibly true.
You can cover that in your memoranda. In view of the lack of material time, can you cover some of the points that you explained to me in your memoranda, Solgen?
Yes, Your Honor.
Thank you. Can I ask Oceana? So this is government, this is private sector.
Yes,
correct?
Your Honor.
And Oceana is, what are you?
We are essentially, Your Honor, we are representing the Filipino people here. And everyone.
No, what
who-
is Oceana? Are you an NGO?
Yes, Your Honor, we
And
are.
How long have you been in your advocacy for stricter monitoring, control, and surveillance?
If I remember correctly, Your Honor, it's about a decade now.
And you are not only here in the Philippines, but you're connected with an international network. Is that correct?
Yes, Your Honor.
As a matter of fact, you participated in a lot of advocacies,
Yes, Your Honor. We have
including the ones resulting into these FAOs.
exactly, Your Honor.
Yes.
The
And-
FAOs are products of a mandamus petition from us before, Your Honor.
Okay. So, in other words, you do have expertise in terms of this subject matter.
Well, I would not call it expertise, Your Honor, but we have extensive knowledge, Your Honor.
Yes, and you can point to scientific studies which actually say, and I have here 8 of them, on the Philippines, which actually says how overfished we are.
Yes, Your Honor.
You can point to them,
Yes, Your Honor.
and you can show that in your memoranda.
In fact, Your Honor, we have pointed to at least one government citation in our opening statement of the
Yes, you did.
National Stock Assessment Program, Your Honor. I think it was 2015,
Yes.
where the government itself stated we are overfished.
Yes, and your interest is because as a public interest organization, you want to actually represent those that are not represented in this particular case
Exactly, Your Honor.
with your perspective.
Yes, Your Honor.
Correct. Okay, now in our environmental rules, we allow citizen suits, correct?
Yes, Your
And
Honor.
you were wanting to intervene as a citizen.
Not just as a matter of right, but as our duty, Your Honor.
Okay, now, there's a difference between citizens like you and the citizen just passing by the sidewalk out there, correct?
Depending on
Insofar
the-
as these issues are concerned.
Yes, Your Honor.
Yes, and when we say citizen suit, sometimes there are people out there that simply file here without the requisite knowledge.
Yes, Your
I
Honor.
can mention a few names, one starting with D, another with M, another with N, that keep on filing cases here because they want the 15 seconds of fame. That when they file on a certain controversial issue, which they are not really knowledgeable about, it is reported in media, correct?
Yes, Your
But
Honor.
at the end of the day, we dismiss it because they cannot move forward
Yes.
in terms of their expertise.
Yes, Your Honor.
But you are the ideal citizen that comes here in order to be able to intervene with your scientific and knowledge and experience.
Not just us, Your Honor. Even the municipal fisherfolk are represented before the court. Your
And
Honor.
you're coming here to question the abuse of discretion in not allowing you in the lower court case.
Especially since, Your Honor, that standing is liberalized in environmental cases.
Yes. Okay, by the way, you're not the only intervener.
Yes, Your Honor.
There is a person that you name in your petition, correct?
Yes, Your Honor.
What is the name of that person?
It would be Kapabs, Your Honor, and Karonod.
Yes, Mr. Rosales.
Yes, Your Honor.
Who is Mr. Rosales?
Mr. Rosales is a municipal fisherfolk, Your Honor. But if I may, I would like to call on my colleague who can represent Mr. Rosales more
Yes,
directly.
please.
Thank you, Your Honor.
Kasi hindi kayo tinatawag kanina para lang maka-appear naman kayo. Okay,
Thank
no,
you,
I'm
Your
just kidding. Okay. Yes, please. Is Mr. Rosales a big-time fisher?
No, Your Honor. He's a municipal fisher po.
And he is national president of an organization. correct?
Pangisda, Your Honor.
Yes. And is he a member of the National Anti-Poverty Commission?
Yes, Your Honor.
Is he also a member of the National Fisheries Aquatic?
And Pharmacy.
Yes.
And Pharmacy, Your Honor.
Yes. As a municipal fisherman, fisher, not fisherman, fisher. How much does he, how many kilos of fish?
It would depend, Your Honor, but it would be enough for them to sustain on a daily basis, Your Honor.
So in your pleading, you said in 2014, he would only catch 5 kilograms every day, correct?
Yes, Your Honor.
And his average earning is how much?
About,
In your pleading, you said 80 pesos.
yes, Your Honor.
So there is a difference between those that commercially fish outside the municipal waters and municipal fishers, correct?
There's a great difference,
A
Your Honor.
great difference. And the greatest difference is the amount of catch,
Yes, Your Honor.
right?
And the amount of capitalization that
The amount
they
of
have, no?
capitalization. And these are people who are only surviving just because they fish,
Yes, Your Honor.
correct? And to earn 80 pesos in 2014 daily,
It's below the poverty line. Your
below
Honor.
the poverty line, correct?
Yes, Your Honor.
And therefore, this was the person that was not allowed by the lower court to intervene.
Yes, Your Honor.
And therefore, because the lower court, can I say, assumed that
Yes.
government will adequately represent him or people like him, or they did not
They're-
want their point of view.
Or they're
What is it?
just curious bystanders, Your Honor.
Yes, and if citizens are allowed to sue under our environmental rules, should the court always consider that those who are below the poverty line be allowed in order to say that there is inclusivity and access to justice in this court, correct?
The court should, Your Honor.
Yes, and you are also on certiorari to question the grave abuse of discretion in not allowing Mr. Rosales and the companion
to intervene, Your
to
Honor.
intervene here,
Yes,
right?
Your Honor.
And again, my heart bleeds because I don't have time to question you on your petition due to lack of material time. But this is just an example of how marginalization works.
That's
correct?
why, Your Honor, we are asserting that the Fisheries Code is also a social legislation. Your Honor.
Yes, and therefore you would cover in your memoranda a lot of the technical issues that were actually raised, from procedure to the substance of what a property right is, what government has done, etc., so that you will be fully heard. Correct?
Yes, Your Honor.
Yes. Thank you.
Thank you, Your
That's
Honor.
all.
Mr. Solicitor General, just a few procedural questions. You filed
Good evening, Chief.
There are two petitions you filed before the court.
Yes, Your Honor.
The first one is a
One is a
petition
petition for certiorari questioning the issuance of the
under
preliminary
Rule 65.
under Rule 65.
And then the second petition is a petition for review under Rule 45.
Rule 45 petition.
Would you not consider the second petition rendering the first petition moot and academic?
That is true. The first petition has been rendered moot and academic with the rendition of judgment by the trial court. But we are still asking the court to make a ruling because of a certain issue there that has not been clarified by the court until now. And that is on the issue of whether or not a lower court may issue injunctive relief in environmental cases. We want to be guided, Your Honor, by your ruling on this petition for certiorari.
Now, what is the basis for the issuance of the WPI? Are you relying on the Fisheries Code or the rule on environmental cases?
Your Honor, we are on both.
So you're relying on both. As pointed out by Justice Kadiwa earlier, it would appear that you look at Section 134, court can issue WPI if a hearing was conducted, right?
Yes, Your Honor.
The prohibition is ex parte issuance of WPI.
Yes, Your Honor.
Now,
But
you said earlier also that Sections 134 and others, if you look at the Fisheries Codes, falls under administrative adjudication.
yes, it falls under the heading of administrative adjudication. So it would appear, Your Honor, that that particular provision, 134, would only come into play where there was prior administrative adjudication and the adjudication made by the BIFAR was brought before a municipal or
So my
trial court, which
question
is not
is-
the case here.
My question is, can Congress by legislation provide for procedural rules, such as provided in Section 34?
Your Honor, I think it's the Supreme Court which has jurisdiction on the matter of
So
rulemaking for courts.
So you're telling us when Congress passed that provision, Section 134, restricting the issuance of WPI except through ex parte proceeding, Congress exceeded its power, right?
In a sense, yes.
So
In a sense, yes, Your Honor.
they did exceed because they cannot legislate on procedural issues, which is strictly under the Constitution within the power of the Supreme Court.
Correct, Your Honor.
Now you filed the second petition under Rule 45,
Yes, Your Honor.
petition for review, because you are only raising pure questions of law, correct?
Yes, Your Honor.
If that is the case, then you admit the factual determinations of the trial court already.
In a way, yes, Your Honor, but
Exactly.
these are the constitutional issues that we're really attacking.
Exactly, but because of the lack of failure on their part to question the factual findings of the trial court, you should be bound by it. For example, the trial court, based on the evidence, has determined that the fishing grounds are trade secrets. Why did you not observe the hierarchy of courts so you can assess the factual determinations of the trial court?
Yes, Your Honor, because we thought that the matter involves a matter of transcendental importance, and we thought that considering that it involves it involves constitutional issues, and that there is some urgency in the sense that a certain community, I'm referring to the European Union, has already threatened to ban Philippine exports. So we believe that because of the exigencies of the situation, we thought that we should go to the Supreme Court
Were you the
directly.
Solicitor General at the time of the trial in the lower court?
No, I was not the Solicitor General at the time of the trial.
When the petition was filed in the Supreme Court, were you the Solicitor General?
Not yet, Your Honor. I was not.
If you were the Solicitor General at the time, would you observe hierarchy of courts? Because that's a crucial legal issue. Because by determination, by coming to court under Rule 45, that means you admit the factual findings of the trial court, then you are bound by that.
On the matter of the petition for certiorari, I would have considered going to the Court of Appeals. On the matter of appealing from the decision of the trial court, since we are raising mostly constitutional issues, then I guess it was a correct thing to
Or
do.
should be the other
Rule
way
45.
around. It should be the other way around. You should have gone to the Court of Appeals in both instances.
To the Court of Appeals on...
The first issuance.
No, but we are raising legal issues only on the petition for review on
Yes, under
certiorari.
Rule 45 you filed here.
Yes, Your
And
Honor.
as I said earlier, when you filed 45, you are bound by the factual findings of the trial court because you did not seek a review of the factual findings. The factual findings of the trial court under the petition for declaratory relief should bind you. An example of that is that the trial court found that there was already a trade secret with respect to specific fishing grounds.
Well, the matter of a determination that a thing is a trade secret, Your Honor, is not necessarily a question of fact.
But there is basis for the trial court to determine that. That is a factual evidence.
That's true, Your Honor, but I believe that even if we consider it a factual issue, the Supreme Court is not precluded from making a review of that conclusion, which I believe is not necessarily factual only.
But in the 45, you see, the question of law is that there's a state present of facts, and we just interpret the law based on the facts that is not disputed.
Yes, Your Honor, but saying that something is a trade secret is a conclusion.
Then you
It's
should
not
have,
a fact.
You should have presented contrary evidence. Did you at the trial court?
Well, probably, Your Honor, but that
Did you at
is...
the trial court level? Because we rely on the decision of the trial court, directly bringing it to the Supreme Court.
That is true, Your Honor. So we agree that we are bound by certain
The
factual
court can review
findings.
facts, you see. If there are countervailing evidence, did you present countervailing evidence on the findings of the trial court that there is trade secret with respect to fishing grounds?
It's basically on the arguments, Your Honor. If it claims that if the petitioner there or the plaintiff claims that it's a trade secret because they had been developing this way of catching fish for a long period of time, then there's really nothing that we can counter that with. That is the allegations of the plaintiff. But we can dispute that that is not tantamount to a trade secret. So it's basically on the level of argumentation.
That's precisely the point. There was no review of factual issues because you did not observe the hierarchy of courts. The Court of Appeals could have reviewed the facts, and then from there you come to the court under 45. Then we can examine the facts now. Anyway, did you consider the defense of slap suit in the trial court?
No, I don't think that was considered.
Did you not raise that as a defense? In the trial
It was raised, Your Honor. The defense of slap was raised in the trial court.
Why did you raise the defense of slap? Have the respondents here exerting undue pressure, stifle any legal recourse? What is the basis of saying that the declaratory relief filed by the respondents at the trial court is a slap suit?
I will just have to review the records of the trial court case, Your Honor. I'm not sure whether evidence was presented to support the defense of slap.
It appears that they raised that as a defense at the trial court. Now, question. The purpose of this installation of this BMS, vessel monitoring system, is to assure there is no illegal, unreported, unregulated fishing, IOU, right?
One of the purposes,
Okay.
Your Honor.
Can the BMS detect if cyanide fishing was resorted to?
No, Your Honor.
Can the BMS determine if the fishing vessels accurately reported what they caught?
That is possible, Your Honor, because there would be a system of validation.
Can the ECM determine that gadget that the fishing vessel fished at a regulated area?
Yes, Your Honor, that can be detected
They can
because
be-
it would set an alarm if a certain vessel would be traversing
Okay.
a restricted zone.
Can the BMS determine overfishing?
The matter of overfishing is the subject of studies based on the data collected through the BMS.
But the gadget cannot detect.
Definitely
overfishing.
not, Your Honor. It's just the catch for that particular day, but the whole thing aggregated together.
So the output desired from the use of BMS is no different from the present manual reporting being done by these fishing vessels.
In a sense, yes, but it's real time, it's digitized, it's less prone to human manipulation,
Why not
and
prone to
for
human?
quick enforcement.
But the reported data is based on the reporting of the human factor, right?
Yes,
the
Your
one
Honor.
encoding. So how reliable is the effectiveness of this gadget of the BMS?
Well, that is very true, Your Honor, because if there is an intent really to transmit fraudulent or incorrect data, that is still possible.
Now, how do you address the illegal fishers? The vessels are not registered. They are not installed with BMS.
Yes, Your Honor, but as I said, even without the VMS, there may be some other equipment that would enable the BFAR to
That is,
detect them.
if the vessels are equipped with AIS.
Yes, only if they are equipped with such other
But if
devices.
the vessels are illegal per se, no AIS, no BMS, how do you now say that you can detect illegal fishing and IUU fishing?
Well, according to the BFAR, even those without any equipment at all may be faintly detected.
Now,
Not completely blank,
your
but
premise
faintly detected.
is the government must ensure that laws are enforced, correct?
Yes, Your Honor.
Now, if the government cannot provide the numbers of coast guards or BFAR vessels to detect these fishing activities, who should be blamed?
Well, it's a question of resources for this matter, Your Honor. That is why the BFAR is trying to look for the most cost-efficient way of doing things.
Exactly, but the point is one of the rules in administrative issuance is that administrative feasibility is required in the enforcement of administrative regulations, right?
Yes, Your Honor.
That's one of the principles.
Mhm.
So the question is, with this implementation of FAO 266, is there administrative feasibility considering that you cannot cope up with the volume of vessels conducting fishing vis-a-vis the number of people that can monitor them?
No, Your Honor, these are complementary measures. It doesn't mean that when we adopt this VMS system, we will not be improving, for example, on the matter of increasing the complement of the PCG or the PNP maritime group. These are all complementary depending on the resources of the government. So what we are just trying to do here is adopt something that will be most efficient and the least costly for the government. But it doesn't mean that we will not provide other means for preventing IUUF or for that matter, even on conservation measures.
The data collected using the PMS, where are they stored? Cloud?
I'm not too technical about it. Your
May you ask the BFAR where they're storing the data? Where they're stored? On the cloud? Or you have a server?
They're stored with the BFAR, Your Honor, the facilities of the BFAR.
You have a server.
Server, yes.
Where is the server located? How secure is the server? Who is maintaining the server?
BFAR?
Good afternoon, Your Honors. The data is being stored in the Fisheries Management Center, and it is equipped with ensuring that the data is stored in equipped with strictly web applications that cannot be accessed by any other personnel except those authorized only, Your Honors.
Okay, thank you. Mr. Solicitor General, there are several tests in determining the constitutionality of laws, regulations, right?
Yes, Your Honor.
For purposes of determining the constitutionality of FAO 266, what test should be applied by the board?
Rational basis test, Your
Rational
Honor.
basis test.
Yes, Your Honor. The rational or reasonable connection between the government's concern and the means actually taken to.
Is the means reasonable under the circumstances?
I guess so, Your Honor. This is the most cost efficient and more in terms of efficiency of producing the desired results, Your Honor, on real time, near real time.
Since you have the statistics on how many apprehensions or violations of the fisheries code was effected since the time you required the use of BMS, you have the data?
Yes, Your Honor, but we cannot really say that the apprehensions, because there's no qualification, that the apprehension was through the assistance of the VMS. But we have the data before and after the adoption of the VMS system.
Because the report cited by Justice Marvick Leonen, it was the Coast Guard who apprehended the illegal fishing, not the use of BMS. So can you submit us the data?
We will submit the data, Your
Please
Honor,
do that.
on apprehensions
So we
by.
would know the effectiveness of BMS.
Yes, Your Honor, we will do
Making
so.
sure the provisions of the fishery code are enforced properly.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Mr. Solicitor General. Okay. Since considering the conclusion of the oral arguments today, parties are required to submit their respective memorandum 30 days from today. Okay, all parties, including the interveners.
Yes, Your Honor. Thank you.
Madam Clerk of Court, are there other matters?
There are no other matters, Your Honor.
We adjourn this afternoon session.
Please rise. Please remain standing while the Chief Justice, the Senior Associate Justice, and the Associate Justices leave the session hall.